So let's start today's webinar. The topic is issues of delayed payments to MSMEs, challenges and solutions. This is something which is happening to the MSMEs on a daily basis and to a large number of MSMEs. So that we keep covering this topic again and again because we keep getting the same amount of responses every time, and we are looking forward to help you and assist you in this regard, and that is why we have come up with this webinar again. So let's start. What all we are going to discuss in this meeting, will see that. So agendas for the discussion in the webinar today would be the definition of MSME under Micro, Small and Medium Enterprises Development Act, how it is defined, how is enterprise defined, how is micro, small and medium enterprises are defined under the act, right? We'll discuss that. What are the qualifying conditions to apply for registrations under MSMED Act? So what are the qualifying conditions for an enterprise to get itself registered in each of these categories, right? So either be it small, micro or medium enterprises. So we'll discuss the qualifying conditions, right, to for an enterprise to get itself registered in any of these categories. So, and third one is the challenges and issues pertaining to delayed, defaulted, stuck payments from buyers. So what are the challenges, what are the solutions, what all the challenges gives, the challenges are consequential in nature, right? When you have defaulted nature of payment, all other challenges you face, right? So we'll discuss those also, the consequential effect and the consequential challenges which arises after the default payment issues, right? And the fourth one is the important provisions under MSMED Act for the benefit of MSMEs. So this act has been drafted as a central piece legislation for the facilitation and assistance to MSME, right? So what all are the provisions which are there under the MSMED Act for the benefit of MSMEs? We'll discuss those provisions. We'll skim through those provisions once, and then we'll come to the solutions and way forward to resolve the issues of delayed payments. So when the delayed payment issues have already arisen, so what are the solutions and way forward for each of the enterprises for a better resolution of their disputes, right? For recovering their delayed payments. Right. So what are all the solutions and way forward for doing it? We'll discuss those also. And next is the preventive measures to avoid the late payment that can be adopted internally. So we have devised some internal measures that if you would adopt it internally, it reduces the chances of the default payment up to a greater extent. So we'll discuss all those preventive measures that you can adopt internally in your businesses so that it can significantly reduce the possibility of getting into default payment issues with other enterprises, right? And then we'll talk about the resolution mechanism, the alternate dispute resolutions and the online dispute resolutions, right? So there are two ways in which you can do it. The alternate dispute resolutions, now everybody must know that it involves in itself conciliation, mediation, and arbitration, and all of these things are done online. Also, there are many platforms which are operating now in India, which do all of this exercise on an online basis. So it is very much efficient for all the parties to get their services, right? We'll discuss that. And the next one is litigation. So if you do not have the facts and circumstances which gives you the benefit of going to or approaching the MSCFC, then there are other ways in which you can recover your payments, that is through litigation. So we'll discuss those also, the litigation, what all are the other laws in which the recovery mechanism works and which you can adopt as per the facts and circumstances of your cases, right? And last one is the things to keep in mind while doing businesses for its effective management, tips and suggestions. There are some tips and suggestions that we have devised after conducting these webinars and after dealing with cases long. So there are some tips and suggestions that we have in mind that we'll pass it on to you, and we hope that it streamlines your management in an effective way. So let's move forward to the other slide. We'll discuss what are the qualifying conditions of the MSME and what are the definition. So the condition precedent to be registered as MSME under MSMED Act amended by the notification dated 26/6/2020. So earlier there was only two categories in which MSMEs got themselves registered into, right? If they were manufacturers or service providers, then only they were eligible to get themselves registered under the MSME category. But from 26/6/2020, the MSMED Act has extended it registrations for traders also. However, having said that, the uh, traders are not given all the other benefits which manufacturers and service providers are given, right? So traders are only given sectoral benefits of such as borrowings and the schemes. So uh, limited extent benefits are provided to traders. Not all the benefits under the MSMED Act are provided to traders. So to say that there is only one sector of benefit that is given to the traders, not any other benefit is provided to the traders. So if you are going to resolve your disputes, please keep in mind that being a trader, you cannot go and opt for MSEFC. Your reference would be rejected at the first instance, right? So only manufacturers and service providers can go to MSEFC, because the dispute resolution mechanism which is there under the MSMED Act only gives benefits to the enterprises which are either manufacturers and service providers, not traders. So the two parameters basis which classification is made between MSMEs are investment made in the enterprise. So what are the investment that you have made in your enterprise, which includes the investment made in plants, machineries, and equipments. And the other parameter is the turnover generated by your enterprise in any preceding financial year, right? So all these parameters, these two parameters are taken into account for as a qualifying condition for you to get yourself registered in any of these each categories, right? Whether it is micro, small, or medium enterprises, right? So the parameters lay out the quantum of investment and turnover required for the registration as MSME under the MSMED Act. So how does it, how are the qualifying conditions are made, right? So the parameters are in such a way that if you have certain amount of investment in plants and machinery, and you have a certain amount of turnover generated from that enterprises, and if you fall in the categories as laid out in the parameter, then you would be eligible for yourself to get registered under that parameter, under that category, right? So we'll see that category now in the other slide. So let's move to the next slide. So this is the table laying out the quantum of investment and turnover for enterprises to be registered under any of these categories, that is micro, small, or medium enterprises under the MSMED Act. One thing more to remember is the medium enterprises are also not given the benefit of MSEFC. So even if you are medium enterprise, still you cannot go to MSEFC. That the MSEFC by its full form is Micro Small Enterprises Facilitation Council. So in its name also you'll see the medium is missing, right? So it does not entertain the medium enterprises references, because it is only for micro and small. So the benefit is only for the micro and small enterprises. Please bear this in mind before making references to the MSEFC, right? So what are the micro enterprises? If your investment made in enterprise is less than 1 crore and the turnover generated annually by you is less than 5 crore or till 5 crore, then all of your enterprises in which you have made investment which is lesser than 1 crore or exactly 1 crore, and the turnover generated by that enterprise is ranging from 0 to 5 crores, somewhere between less than 5 crores or equivalent to 5 crores, then you will be registered as micro enterprise. So there is not any lower limit, as you would say. There's obviously a upper limit. So any investment which is lesser than 1 crore, be it 1 lakh, be it 2 lakh, be it 3 lakh, be it 50,000, and if your turnover is also 50, 60,000 or 70,000, there is no lower limit to say. So if you have this limit, and if you have turnover and investment lesser than this limit as reflected in the micro enterprises table, then you would be eligible for your enterprise to get itself registered in the micro enterprise. Now coming to the small enterprise, your investment made in the enterprise has to range between 1 crore, above 1 crore to 10 crore, because if it is lesser than 1 crore, it would be in the micro enterprises, right? So now 1 crore is the limit for micro, and medium and small enterprises, the investments limit is 10 crores. So anywhere between 1 to 10 crores investment made in the plants and machinery, and simultaneously turnover generated annually should be more than 5 crores and lesser than 50 crores. So if it falls between these range, then you'll be able to get yourself registered in the small enterprises. And going forward, the same is for medium enterprises. If the investment made in the enterprises ranges from 10 crores to 100 crores and the turnover generated annually ranges from 50 crores to 250 crores, then you'd be able to get yourself registered under medium enterprises. I hope I am clear till now. So moving to the next slide now. Now we have come to the main part, reasons for the delayed payments and its consequential effects on MSMEs. So now we'll discuss about what are the reasons because of which the delayed payments occur in the first place and their consequential effects on MSMEs. And the first and the foremost point is not documenting or recording the transactions, delivery of goods, materials, or performance of services without any work purchase orders, not recording terms and conditions in an agreement, not adept with quick turnarounds for reserving rights, etc. The second is extended credit period, continuing with the transactions even after delayed payment issues with the hope of retaining buyer and clients. So let's discuss the first one first, and which is key. I've seen a lot of times, and still enterprises are doing it without any reason to say that they are not documenting the transaction, they are not issuing purchase order or work orders, or they are not asking the other party to issue purchase order or work order, and they keep on entering into transactions without any documents, right? So this is the first and the most detrimental thing that you can do to your enterprise, because any transaction, if it is not recorded in writing, then it is very hard to prove for you. But it is very hard for you to prove when disputes occur that these were the terms and conditions which were agreed between the parties, because there is no recorded evidence of it, right? The terms and conditions are not recorded. So it becomes really difficult for you to prove the terms and conditions, to prove the payment terms, to prove all and every terms that goes into any transaction, right? Because it is not recorded. And a lot of times, because of these things are not recorded, your claims would be lost. You wouldn't be able to prove that you entered into a transaction at all with the opposite party. Now, there are other ways in which you can prove if you have only e-challan, delivery challans, or other things to prove by conduct. But then all of these are quite too difficult to prove in absence of any recorded transaction, right? Any recorded terms and conditions which the parties entered or reduced to, right? So I always say that if you have purchase order, work order with the terms and conditions written there, then it is always beneficial for you to go back to those terms and conditions and to direct the other party if it breaches in any of those conditions, right? And you'd be able to prove it easily if it goes to a neutral party for adjudication of your claim. So if reasons of if issues of delayed payments occur, right, and you go and you take it for the adjudication to a neutral party, then the neutral party, it becomes very hard for the neutral party to accept on your words that you are given a verbal instructions, verbal work order with all those terms and conditions when you have nothing to show otherwise, right? So all of these things may be very much detrimental to you if you're not having an agreement. I always say to have a master agreement. It takes you only one agreement to draw, right? If you are providing services, you can draw a master service agreement for the particulars of the services that you provide, for main services that you provide in your regular uh, business, right? So you can have a master services agreement, a master delivery agreement, master sale of goods agreement that you can draw upon, and you can issue purchase orders and work orders basis on those, right? So that's the same manner in which the government does, right? If you'll enter into a transaction with government bodies, you'd say that you'd see that they have a special terms of conditions, special conditions of contract, general conditions of contract. They have a bid, and they have a bid document which details out each and everything which the transaction can ensue, right? Which those those transactions ensue between the parties, right? So all of these things you can keep in mind before entering into any contract with the other party. Now, the other one is extended credit period. I have seen a lot of enterprises to keep on keep on delivering their services, keep on providing their services, or keep on delivering the goods, even when the other party is making continuous defaults of payment, right? A lot of time they do not want to let go of the businesses that they are having with the other party, because they have the faith on the other party that even if it is not making regular payments, my payments are getting my payments would be made in future, and it would be made without fail. A lot of time these faiths are broken, unfortunately, because when all of the dues are accumulated in a huge number, and when and then the party refuses to pay, then you have nothing to go forward for, right? Because you have already invested and invested a lot of your resources, which are not backed or secured, because you're keep on delivering your goods, and you have made all those deliveries, and those deliveries cannot be reversed, right? So you only can go and you can only demand your due payments from them, and if it is keep getting delayed, there would be consequential effects for your businesses. And when a huge money gets stuck, then it is I need not to dwell much on this, but it is known for businesses that how negatively it hampers their smooth running of transactions and businesses, right? When a huge number of amount gets defaulted or stuck, and and the payment is not made regularly. So all of these things have to be kept in mind, that clearly pick and choose your parties to whom you can extend the credit period, and that depends on a lot of commercial wisdom also of the businesses, that they consciously take, whether how much deliveries that can be made till any payment comes. So all of these have to keep in mind, that you have to be wary of these things, that these things can happen in future, and you do not keep on delivering products or services without any payments, right? So please keep this in mind. And the third one is challenges faced due to competition in the relevant market. Industry specific challenges such as disrupted availability of raw materials, competitive rates with minimal margins of profit. The other one is no bargaining power with buyers to negotiate terms accordingly, market share reductions, alternate materials or services against that of MSME, etc. So these two are business related difficulties, right, which every businesses face. So if you have only one source of getting your raw materials from, or getting your workforce from, so in COVID you have seen the disrupted raw materials and the disrupted workforce availability all over India, right? So and there are a lot of times strikes happen, and a lot of time external due to external factors, you cannot source those raw materials. There might be endless reasons of endless disturbances, curfew, and strikes, which might lead to the disruption of these available man forces and the raw materials for your business, right? So it is always beneficial to have your market share more than in one place, to have your source more than in one place, from which you source man force and raw materials from. And I would also suggest you to have your market also in more than one area, so that your covering of customer increases, right? You are not dependent on any territorial jurisdiction, and the business is generated in that territorial jurisdiction, right? Because it gets affected by a lot of certain external exigencies, right? So if in any territorial jurisdiction there might be a possibility of war, internal disturbances, and your businesses is in those territorial jurisdictions, then it would be very hard for your business to survive, right? Because your businesses would not be doing the operations on a regular basis because of those disturbances. So all of these things you can keep in mind. And no bargaining power with buyers to negotiate terms accordingly. So I've seen whenever MSMEs enter into contract or transactions with a very big corporate house, a big conglomerate, then a lot of times they have their own agreement, which is boilerplate clauses, boilerplate agreement, which you would have to sign. Otherwise, they wouldn't give the businesses to you. But that is the apprehension that all the MSMEs have. So if you are not getting the negotiation on equal terms, then uh, then also you can see that all of these clauses, you cannot let go of those red flags clauses, which would be very detrimental for you in the longer run, just to retain that business, right? So I always say that please try to negotiate those clauses, even if you think that they won't negotiate those clauses. It is not like that. You also have the say in any transaction, whether it is big corporate houses or conglomerate. You can enter into talks with the other party. You can say that these clauses affect us in a very detrimental manner, and these should be changed. So all of these things you should keep in mind. The next one is ineffective correspondences during a transaction, lack of recorded communication between parties, reserving the right to claim liquidated damages, if any, lack of acknowledgement from the buyer regarding irrevocable acceptance, etc., and difficulty in realizing payment from buyers, cash transactions, etc. So all of these difficulties I've seen, all of these mistakes I've seen first-hand enterprises committing, and because I've seen a lot of enterprises, they have disputes, huge number of disputes with a lot of parties, but they are not willing to enter into a dispute resolution mechanism with any professional, where they would issue notices whenever the disputes arises. They issue notices, reminder of payment whenever the time expires, whichever you have given them, the credit limit expires. So all of these things they did not do. They just keep sitting on their delayed payment issues till their limitation period also expires, and then they would wake up from their slumber and they would say, "Ki, please do something about this." So please keep in mind that a professional can only do much if you have also assisted him in that manner, right? If you have let go of your limitation period, then no one can help you. Your claim is lost and you wouldn't be able to claim it at any point of time. So always keep in mind that whenever the default occurs, the limitation is only for 3 years whenever the cause of action arises. So whenever you had that cause of action, that you can go to a court of law, or you can go to a dispute resolution mechanism to recover your payments. And within that time, from that time, within 3 years, if you have not done anything, if you have not taken any action, then the limitation expires, right? And not to say, if I say that you can take actions within 3 months, all there are other actions also. If you do not want to go to the dispute resolution mechanism just yet, if you want to give him more time to make payments, what you can do is, within the limitation, before the limitation expires, before the 3 years period expires, you ask the opposite party to send you an acknowledgement saying that, okay, this is the dispute and I accept the disputes and I will make payment. So what it does is it gives rises to the fresh limitation, right? So the limitation again starts from there, and it lasts for 3 months. So if you keep getting acknowledgement before the expiry of 3 months, it gets renewed each and every time, right? So at least you can do this. But I've seen a lot of enterprises doing nothing, and that is where their claim are lost, right? And so this is what I mean when I say ineffective correspondences during a transaction, lack of recorded communication. So whenever a breach happens, and it is your duty to bring that on record, that the other party has done this breach and this particular breach, and it has in what manner negatively impacted you, or it has resulted in some losses or not. All of these things have to be recorded. All of these things have to reflect in a written manner whenever these things arise. So whenever these things arise because of the dispute, breach, or default payments, the duty it is your duty as an enterprise to bring these things on record, right? All of these things, if brought on record at an appropriate time, would be beneficial for you in a longer run, because even if you go to dispute, you have all the reflected understanding between the parties, and it would be very much easier for you to recover your money if you do not had all of these things, right? So all of these things are very much important as an enterprise. You cannot just sit and sleep on your rights. You have to be vigilant. You have to keep doing effective correspondence with the other party, right? So all of these things significantly reduces the chances of entering into a defaulted payment at the first place. All of these things, if you would adopt internally, and even if it arises, because no one can stop this per se, right? because you would always enter into transactions and some party would always default in the payments, right? So you cannot stop this per se, but then if you have all of these checks in place, then you would be confident enough that even if disputes arises, you would recover your money in a better manner, in an efficient manner, and you wouldn't have to give much thought about it, right? The last one is difficulty in realizing payment from buyers, cash transactions, etc. So when I say the terms should be recorded, the payment should be recorded, I have seen a lot of times enterprises entering into cash transactions, which is again is a mean to say that it cannot be recorded in any manner, right? Until and unless you take signature from the opposite party whenever you have paid cash to him, right? And then again he can dispute it by saying that this is not my signature. So all of these things you have to keep in mind, that cash transactions is riskier in nature than the online transactions, right? And if you are doing cash transactions to evade tax liability, I would suggest you not to do so, because if dispute arises, then your claim would be lost, because you wouldn't be able to take that claim for adjudication, because you were evading the tax on that transaction, right? Anyway, so all of these things, please keep in mind, and these are the reasons for the delayed payments to occur. And right, and even if it occurs, and these are the reasons why your claim amount are not effectively realized by you, right? So all of these things you should keep in mind while entering into a transaction. And please enter into an agreement. Please make an agreement for all your transactions. Being an enterprise, you're leasing a factory, so please make sure that there is a lease agreement in place. If you have a factory and there are 10 more than 10 employers working there, so the Factory Act compliances are applicable for you, right? The all the other compliances comes into picture, right? Like employees provident fund and EPFO contribution you have to make, and all the other labor law compliances, the maternity benefit compliances, the Prevention of Sexual Harassment Act compliance. All of these compliance you have to make as an enterprise. You cannot say that being a micro, small, and medium enterprises would be excused from these compliances, right? And all these compliances, if you're not having in place, then let me tell you that ignorance is not an excuse in law, and you would be slapped with a very huge fine if all those compliances come into light. If it is not coming into light now, then it is good for you, but then always there is an apprehension that some regulatory body would serve you notice, and if you didn't have these compliances, you would have nothing to say but to accept fine. And a lot of time, if you are into food businesses and you're not complying with the mandatory compliances, if you're into drugs businesses, drugs and cosmetics, and you're not complying with the mandatory compliances, it can also lead you. It can also lead you be getting end up behind bars, right? So all of these things, please keep in mind. All the industry specific compliances, go and check out that what industry are you in, what are the compliances that are there in the law. Go and seek out a professional advice to streamline all of these things in the first place, right? I have seen people operating company, but they do not have a good shareholders agreement even in the first place, right? So all of these things are a very a red flag that are there in the genesis, and you're entering crores of rupees of transaction based on those enterprise, based on those shady paperwork, right? So all of these are not very good, not very beneficial for your businesses in the long run. It takes a little bit of money at an early stage, which a lot of enterprises think as a unnecessary expenditure, but let me tell you that it is an investment which safeguards your businesses in the longer run, so that it doesn't get shut down because of the huge penalties by the regulatory bodies, right? So always keep in mind that these are all the investments that you make in your businesses to make it compliance, to make it to make it appropriate in all the compliances and legal regulations, right? So coming to the next slide now. So the consequential effects due to the challenges, there are many consequential effects due to these challenges that we talked about, right? So whenever the conditions, whenever the issues of defaulted payments occur for any enterprise, the first and the foremost is the lack of financial resources, because your financial resources are stuck at some place else, and you cannot appropriate those financial resources into other avenues uh, which would have led to the growth of your company, right, in any manner. So if your financial resources are stuck, it is apparent, and it is it is very much simple that you would face lack of financial resources. I need not dwell much on it. And the second one is lost claims due to not having enough evidence and materials on record to prove default. As I stated earlier, कि अगर आपके पास ज़्यादा evidence ही नहीं है, if you do not have any recorded transaction, if you do not have the understanding recorded in writing between the parties before the transaction or during the transaction, it would be very much difficult for you to claim your losses based on the transactions, right? Because it is not recorded. So a lot of claims would be lost due to because it was not recorded in the first place, right? So your claims are lost. Claims are undervalued if there are not a lot of recorded transactions, and there are only a limited number of transactions that you can prove, accept all the recorded transactions. If you do not have any agreement or any work order or any purchase order, and you have entered into a lot number of transactions with one party, there are only a certain transactions that you would be able to prove by the conduct, and you wouldn't be able to prove each and every transaction as it should have been, uh, as per the verbal directions or the instructions, because you cannot prove those verbal instructions and conditions that were given to you by the other party. So a lot of times your claims would be undervalued if you have evaded tax, then and dispute occurs on the transaction. Then for the tax that you have evaded, you cannot take that part of the transaction to adjudication, right? Because it is illegal, right? And there is only a limited number of amount in the transaction that you have reflected to evade the tax liability. Then your claims would be undervalued, right? So all of these things you have to keep in mind, that all of these are consequential effects to these challenges that we talked about. And the next one is loss of damages liquidated for breach of terms of the arrangement by the buyer. So whenever breach happens, and whenever breach happens, the enterprises face a lot of consequential effects, which is losses. You won't be able to pay your workforce in an effective manner. You would have financial resources, your other financial obligations you would breach upon due to not getting your payments on time. So all of these are loss of damages. You might have to pay interest on the delayed payment that you were not able to complete just because you were not able to realize a payment which was stuck from the other party. So all of these damages you're suffering, right? And the genesis of it is that you are not getting the payment on time from one party. So all of these things should be communicated in a clear terms to the other party, that these are all the losses that you're suffering due to the breach, and all of these losses would be computed in your loss of claims whenever you are going for the adjudication. All of these losses that you have suffered additionally would also be computed in your loss of claims. So all of these things you should keep in mind to have a clear cut communication whenever those loss are happening to whenever you're suffering those loss. You should communicate it to the other party that you're suffering those loss, and the other party would be liable to indemnify you for those losses, because the other party is in the breach, not you. And that is why I say that you have to have an agreement in place which states all of these conditions, right? It states that if the other party is in breach, and this party has suffered losses because of that breach, then the other party who has committed the breach would be liable to indemnify this party. That is in the indemnification clause in an agreement, right? So all of these things, if it is not in agreement, it would be very difficult for you to go and claim, right? So all of these things are interconnected, right? So if you follow this wholeheartedly, it reduces the possibility of getting into disputes, getting into stuck payments, because you have already have an agreement in place which is signed by all the parties. Whenever there is any uncertainty about the transaction, you can always go and visit the transaction, the agreement that you agreed upon, right? And basis upon which you can take your transactions forward. and in the absence of it, the whole thing is haphazard, right? Because you cannot ask the party to comply or adhere to any verbal instructions, because you wouldn't be able to prove those verbal instructions in the first place, right? So all of these things, please keep in mind. The liquidity crunch in the operation of businesses is related to the lack of financial resources. You would have liquidity crunch, you wouldn't be able to source raw material, you wouldn't be able to pay your workforces in an effective manner, you wouldn't be able to adhere to the financial obligations that you have towards the other party, right? Because you're not getting money from somewhere, you wouldn't be able to pay somebody else, right? So it also hampers your goodwill, right? So all of these things happens because of the issues of the delayed payment, right? And the next one is not able to realize the actual amount as reflected in the turnover generated by the MSME, hampering the expansion and growth of business, minimal profitability, not taking proper and relevant professional consultations, resulting in losses. So all of these things, as I have stated earlier, all of these things are interconnected. I've not able to realize the actual amount as reflected in the turnover generated by MSMEs, hampering the expansion and growth of the business. So as you would know, that balance sheet always reflects the transactions that you're entering into, irrespective of whether you're getting the actual amount or not, right? So in your balance sheet, in your turnover, you would be having a much huge amount, which would show that your company is doing good. But in actual scenario, if you're not getting those money in your account, then it hampers the growth and businesses of your company, even if it is reflected in the balance sheet that you have done businesses of this worth, but you do not have that worth in your account to expand and grow accordingly, right? So all of these things happen. The differences in balance sheet profitability and your actual profitability uh, create gets created because you are not realizing the payment on time, right? And it reduces your profitability also, right? Because you are already facing lack of financial resources. And when I say that you're not taking proper and relevant professional consultations, and you end up in getting show cause notices from regulatory body, and you do not have compliances to so, then you result in losses anyway, right? So it is always advisable to go and take professional and relevant professional consultations, which deals with your industry specific businesses, right? So that you do not miss out on to mandatory compliances, regulations, and etc., etc. So that it might result in losses in near future. The next one is ineffective workforce due to lack and vestiges of valuable resources, legal troubles due to ignorance or no knowledge of various industry-specific mandatory compliances. As I'm already stating, that there are certain legal troubles that comes due to your ignorance or no knowledge of your industry-specific mandatory compliances. And as I've already stated, that ignorance in law is not an excuse. That is a settled principle in Indian legal system. So if you say in your defense that you did not know this law, then that defense is not a good defense. That defense is no defense in law. So if there is law, you must know it and you must follow it. So that is how our Indian legal system works. So it is your duty to know all the mandatory compliances of your industry, all the compliances which are otherwise applicable in your industry, such as post compliances. Post compliances is too important. And these days, you have seen the recent horrifying incident in Arjikar hospital, which is sexual harassment at workplace in a most aggravated and most animal-like manner. So all of these things should be in place so that all of these horrifying incidences can be avoided up to a greater extent, right? And you would be responsible if any of these incidents take place in your business and you didn't have mandatory compliances, right? So you would be in a very detrimental and a very weak position, right? So please go and know about the law which are applicable, know about the mandatory compliances which are applicable in your businesses, and then please do all those compliances so that in near future you do not have to face legal troubles, right? So I'll come to the next slide. The delayed payments to MSMEs, challenges and solutions. The solutions and way forward to overcome challenges. The preventive measures that we talked about will substantiate it a bit further, which is to enter into an a written agreement recording the understanding of terms between the parties, duly executed and properly stamped and notarized, work purchase orders to be raised under such agreement, work purchase orders to be shared on an electronic medium too, even if a hard copy of the same is raised, recording each and every transactions, its terms, obligations, applicable interest upon delayed payment, consequences of breach, force majeure, indemnity, dispute resolution clause, clause to notify defect or damaged goods and services, rectification period. All of these things you can incorporate in an agreement, right? I'll substantiate all of these clauses for you in a brief manner. So what is the terms and obligations? So in terms and obligations, you can define the obligations of each party, that if you're supplying goods, then how the supply has to be made, what all are the goods that you're supplying, what all are the qualities of the good that should be, which you are supplying, and the obligations of the other party would be to make timely payments to receive those goods, right? So, on a timely basis, to notify you of any defect which is there in the goods within a stipulated timeline, so that they cannot keep the contract open-ended and come after 5 to 6 months later and say that your goods were defective. So if you have an agreement in place in which there is a clause which states if there is any defect in goods or services which were delivered to the other party, then it should be notified to the other party within 20 days or 15 days of making those deliveries, and you have to give rectification period also, so that it enables you to rectify those defects if at all were brought into your notice within the stipulated timeline, right? So that the transaction is not is terminated in per se, or cancelled by one party. So if you have rectification, then it enables you to go and rectify those defects, right, which are there in your goods, rather than to cancel the whole transaction. So you can already mention the applicable interest upon the delayed payment, right? So if it gets delayed after the extended credit period which you have given to the other party, this would be the interest which would be applicable, right? The consequences of breach, if any party does breach of any of these conditions and obligations, what would be the consequences? And he would be liable to indemnify the other party of any losses due to those breaches, right? So all of these things should be considered in consequences of breach clauses. Then comes force majeure clauses, which is an act of God. So a lot of time, just like in COVID, or whenever a natural calamity occurs, it should be there in the agreement, which releases you from your obligation to to perform the contract in certain exigencies which are there due to natural calamities, right? So in those situations, you're released from your obligations of the contract for a certain period of time till the natural calamity persists, right? So force majeure clause is also important. Indemnity is I already stated that whenever one party commits breach and the other party suffers loss due to that breach, the party who commits the breach would be liable to make good for the losses that the other party suffered because of his breach, right? So all of these are covered under the indemnity clause. The dispute resolution clause is that, like, if you're in Delhi and the other party is in Mumbai, so what you can do is you can specify that the dispute resolution clause and the disputes would be resolved, and the courts of Delhi would have the sole jurisdiction, so that you have the advantage of home turf, right? You do not have to go to Bombay for adjudication of your disputes, right? And it does not drain you of your financial resources, right? So all of these clauses are pretty much important in an agreement if you are entering into any sale of good or delivery of goods or delivery of services agreement, right? So all of these clauses you can consider putting in the clause to notify defect or damaged good. As I stated earlier, that there should be a clause under which you define a timeline, whether under which the defects or rectifications could be pointed out by the other party, that these were the these were the defects which were found in the goods, right? And beyond that point, the goods would be deemed to have been unequivocally accepted, right? So all of these clauses you can incorporate in your agreement. Now, coming to the second point is being adept with communications, deserving of rights to claim damages, if any, receiving acknowledgement of the due amount from the buyer, taking steps to resolve issues before the claims are barred by limitation, follows up on delayed payments, balance payments, intimation of the applicable interest, not diluting its rights as a party by way of conduct, negotiating and careful of the agreed payment terms, whether advanced at the time of delivery payment made within specified period, right? So all of these things you should keep in mind, that you have to adapt with your communications. Whenever breach happen, you have to notify to the other party that you have committed this breach. This particular breach has been committed by you, and whenever you are suffering losses because of such breaches, you must notify the other party of those losses whenever it is happening to you in real time, right? So if you do so, then it is a lot easier for you to prove those damages in adjudication, right? Because you have written those things. You have made those records prior to you entering into a dispute. So it shows your uh, vigilance in doing business, right? And it also shows that these are not afterthoughts that you had after the disputes were created, right? So all of these things, if done in the real time, would be very much beneficial to you in the longer run, for you to prove your credibility, for you to prove the credibility of the transaction as it took place, and also to recover damages and your actual claim, if it is stuck or defaulted, right? So you have to take acknowledgement of the due amount in the apprehension that the limitation does not expire. You have to keep vigilant about the limitation, right? So that the limitation doesn't expire, right? So you have to keep following up on your delayed payments. Whenever the time limit expires, you have to write mail that your time limit has already expired. If you do not pay us the amount, the interest would be this much interest would be chargeable, right? Intimation of applicable interest, I said, not diluting it, right, as a party of way of conduct, negotiating and careful of agreed payment terms. You can always negotiate payment terms, always write that you not give payment terms beyond 45 days to the other party, because it is already recorded as 45 days in MSMED Act. So if the Act does not give more time than 45 days, then I would advise you to not give more time than 45 days for any party to make payments of any delivery goods, for any delivery of goods that you have made or any services that you have provided. Now we'll come to the next slide. The next slide is taking proper consultations from relevant professionals. I would not again substantiate it, but to give you a brief understanding that what are all the other secretarial audits and mandatory compliances that you need to do. There are GST forms that you need to submit on a regular basis, on yearly, annually basis. There are income tax forms. There are, if you have a company, there are ROC forms that you have to submit to the ROC. So all of those forms, audits, secretarial things you have to keep in mind, because there are also penalties if you do not adhere to all of these compliances by ROC. So let's say that company law says ki if you have not made certain declarations which are mandatory in law for more than 3 years, then you are barred from being a director in any company for the next 3 years, right? So you'd lose your company as a director, and you wouldn't be able to be a director in any other company for 3 years, right? So all of these things, please keep in mind, so that you do not uh, face unnecessary troubles just because you didn't know about them, didn't know about the mandatory compliances. To carefully assess damages clause in the agreement, computation of claims under various heads such as price escalation, overhead charges, machinery and workforce idlement charges, etc. So all of these damages, whenever you enter into a contract, so let's discuss about works contract, because a lot of MSMEs are into construction businesses, right? They do works contract for government, non-governmental entities, right? So whenever your payment are dues, it is not like those are the only sole claims that you have. there might be price escalation claims, that there might be overhead charges that you suffered, that that you had to bear. There might be machinery and workforce idlement charges that are there. So you have to seek out relevant professional who would assist you in carefully assessing these damages, because these are based on factors and the actual losses that you have suffered, and you can compute those claims so that your claims are not lost, right? And if it is in if it is a case of liquidated damages, what are all the liquidated damages that are already there in the agreement, whether it is a pre-genuine estimate or not. All of these things you should be wary about. You should see that it is reasonable and appropriate as per the law, right? To be well versed with all the schemes, benefit policies, and government affecting policies by the government affecting MSMEs. So this is what the UDYAMITA helpline does, right? So it facilitates it is a platform where all the schemes, benefits, and policies of the government which are there for the MSMEs are accumulated, and these are disseminated in a knowledge form to all the MSMEs, so that it would facilitate them and assist them in their businesses, right? They also have the dispute resolution mechanism assistance in place, where they call upon experts like me to talk about certain issues which all the MSMEs face, which are related to the delayed payments, right? So all of these things you should be updated about the policies, the ongoing schemes, the ongoing benefits which are there for the MSMEs and which are operating in certain industry specific area. So if you're under agricultural businesses, there are industry specific schemes and benefits for agricultural by agriculture to the agricultural businesses. So there are industry specific policies schemes also that you can keep yourself updated with, and these would benefit you in a longer run if you are just well informed. So any enterprise who is well informed and aware of their rights, duties, and schemes and policies affecting their businesses, then there is a huge possibility that their businesses would flourish, right? So all of these things are pretty much important, as important as your businesses as well, right? So all of these things you should keep in mind. Coming to the next point, to safeguard the interest in the businesses, creating strategic assets, raising proper invoices with GST, IN, UAN, PAN, and be updated with statutory tax and other filings. So as I said, there are certain filings of forms which are for RSC, which are for GST, for income tax. You have to keep yourself updated with that. You have to safeguard the interest of your businesses. You have to safeguard the goodwill of your company by investing in trademarks, getting trademarks of your business's logo, right? From which the customers relate to you, the logo of your company, which is there in the mind. So you can always get it safeguarded by getting trademarks of those businesses. If you have any technology, you can get yourself a patent. If you have a design which is very much prominent, and which in which you have invested a lot of resources, you can go for designs act registration. And if you have any original work with yourself, then you can go and you can create copyrights. So all of these things are investments only, because these things carry certain these things can be computed in terms of monetary arrangement, because whenever you will see the transfer of assignment of trademarks, one party pay to the other party a sum of amount. That sum of amount is the invested amount what the trademark now holds for you, right? So all of these things are investment. They have a certain value attached to them, which they acquire with passing of the time, right? The goodwill, it would enhance day by day by you getting businesses, by you performing well, right? And at one point of time, uh, they also have certain value in money attached to them, right? So all of these things are investments for you, and you have to create your strategic assets for your businesses, so that it is not diluted by other company. So let's say if you do not have any protection for a trademark or a logo of your businesses, and the other party just comes up with the same similar logo, then you can only go in civil liability of passing off, but you wouldn't you cannot go under the Trademark Infringement Act for for uh, for injuncting the other party from infringing your trademark. So all of these things, please keep in mind. You can go and create strategic assets if you think your businesses needs one. And coming to the next point, being adept with the follow-ups of payments. So it is your payment. You have to realize the amount. So you should be aware, vigilant about the time of the payment getting expired, right? So whenever it gets expired, you have to follow up with your payment. It shows that you have been vigilant about your payment from the other party. It also shows that you are in the need of the payment, and you did not get the payment, which might have led to other losses for your company, right? So all of these things benefit you in a holistic manner if you're adept with the follow up for realizing your payments, right? And the last one is acquiring a post-dated check for the bill raised as a security measure to avoid delayed payments. So whenever you're wary of getting your payments from any other party, then what you can do is you can take a post-dated check for that amount, which is going to be the consideration for that transaction, right? So that you are safeguarded you have safeguarded your investment, uh, which you have made, right? And the transaction, the amount of transactions is secured with you in the manner of post-dated checks, right? So these things that you can do, and if you do these things, it reduces the possibility of getting into delayed payments at all. And even if you get into delayed payments, it reduces the possibility of not getting anything just because you did not have anything to prove the claims that you're seeking from the adjudicating body, right? So all of these things, please keep in mind. And next, I will go to the next slide. Now we have come to the external solutions, resolution of disputes, litigation, ADR and ODR. We'll talk about the MSME, the provisions under MSMED Act, the proceedings under the Section 138 Negotiable Instruments Act. We'll talk about insolvency and bankruptcy code and the procedures under it. We'll talk about Arbitration and Conciliation Act in general. Then we'll talk about summary suits, including civil suits, including summary suits, and then we'll talk about mutual resolution. So coming to MSMEs now. So Section 7 to 14 are general sections which are there for the benefits of the MSME. Section 7 says classification of enterprises, how they would be classified. Section 9 says measures for promotion and development. Section 10 says credit facilities. Section 11 is procurement preference policy. All of these sections are for the measures and promotions and developments of MSMEs. What are all the credit facilities that can be extended to the MSME enterprises? The procurement preference policy is something by the government which in tenders or in procurement policies give preference to MSME rather than the lowest bidder if it is not MSME, right? So that is covered in the procurement preference policy. Section 12 is funds, Section 13 is grants by the central government, and how Section 14 is how those funds would be utilized and how it would be administered. Now the resolution is the dispute resolution mechanism starts from Section 15. Section 15 says liability of buyer to make payment. It says that whenever a supply is being made, whenever a service has been provided to the other party, there is 45 days for making the payment for those supply of goods or the delivery of such services, provisions of such services, right? And after the 45 days, Section 16 states that date from which and rate at which interest is payable. So date from which, after the 45 days from 46th date, interest is payable. What is the interest which is payable on the delayed payment? So if it goes beyond 45 days, it covers under the delayed payment, because the 45 days is only the eligible period for you to make payment for any delivery of goods or services, right? So if it is 46th day and interest is applicable, what is the interest? The interest is 3 times the interest rate notified by the RBI for these purposes, right? So there is an interest rate which is notified by the RBI. Generally, it ranges between 6.5%, and the 3 times of that interest rate, which is compounded on a monthly basis, is applicable on the delayed payment from 46th day onwards, right? So you can keep this in mind, because this is a penal provision, so to say. So if you're not making timely payments to the MSME enterprises, you should keep in mind that there is a huge penalty in way of interest stipulation, which you'll have to bear with the principal amount, right? So it is a lot beneficial for the MSME. And if you go to MSEFC, then they would grant you interest on these on basis on this calculation, right? So this is a very beneficial provision for MSMEs, so to maintain their liquidity, uh, and so not to make them make them make them run behind an enterprises for realizing their payments every time, right? So section 16 we talked about. Now coming to section 80 is section 18, reference to MSME. Section 19 is application for setting aside decree, award, or order, and section 24 is overriding effect. So section 18 is reference to MSEFC. So whenever you have disputed delayed payment issues with any other party, and the transaction that you entered into is post your registration, then you can approach the MSEFC for making a reference application to MSEFC saying that this is the amount which is due from the other party. Kindly direct the other party to pay me this amount. So if you make a reference application in this application under this section, a notice is issued to the other party that we have received this case against you for this much amount. If you have anything to say, please say in your defense, or otherwise make this payment. So now 1 month, 2 month time is given to the other party to make payment. Generally 1 month time is given to the other party to make payment, or to say something in their defense. If let's say they have something to say in their defense, they issued a reply uh, against your application reference application, then that reply would be that reply would be served to you, saying the opposite party had this to say, what are your views on it. And now you can state that still he had this defense, but you do not agree with what the other party had to say. Then you can ask the MSEFC to proceed with the dispute resolution mechanism, which is, first the other party would be called upon to do conciliation. Both the parties would meet online or offline in physical manner, and they would conciliate, right? And if they conciliate, they agree on a term, right? They mutually resolve their dispute, then it is well and good. Settlement agreement would be drawn, and the other party would be released from the MSEFC jurisdiction, basis on those settlement agreement, that the terms on which the parties agreed upon, and the other party would pay this party as per the settlement agreement. But if the other parties are not successful in conciliating their disputes, or reaching a consensus, then the dispute are referred to arbitration. An arbitrator is appointed by MSEFC. It can be an external body or the MSEFC itself. The other party, you'll be called upon to submit your statement of claim. You'll submit all the statement which and the claims which you want to seek from the opposite party. How did those claims came to be? What are all the evidences for all the claims that you are making? All of this you'll submit in statement of claim to the opposite party. Now you'll submit to the MSEFC. Now the opposite party would submit a statement of defense. So whatever he has to say in defense, that this claim is not applicable because this much I have paid and only this much amount is left as per our calculation. So all of these things you'd say in statement of defense, whatever defense that you have, or you have to say. So you think that you do not have any liability to pay. So what are all the defenses that you have? You will have to say it in statement of defense. Even if you have counterclaim, you can raise your counterclaim to the opposite party, that I also have claim. If the applicant has claim, I also have certain claims from the opposite party. And then the arbitrator would hear all those things. If he would see that there are counterclaims also, there are claims also, he would set off those claims, and whatever due to the parties are given in an award, right? So whatever the arbitrator thinks that the one party is liable to get from the other party this much amount, he would say that this party would pay to this party this much amount, which is called an award. And what they will do, they would give the interest as per the section 16 of MSMED Act on that principal amount while awarding that, while making that award. And now the best part under this is MSMED Act is, if it would have been a normal arbitration, the other party could have gone and challenged the award, right, to the court of law. So still it gets concluded, you won. Yeah, the arbitrator has given you an award, but what the other party is doing, that it keeps on appealing, right, so that he doesn't have to pay in actual, because he can go to the district court for under section 34, or can go directly to the high court under section 34. Then he can go under section 37 in an appeal for that in high court, right, or before the division bench, and then he can go to the supreme court, right. So all of these things take a lot of time. So what section 19 has done is, if any appeal has to be made from an award which has been passed by MSEFC, the other party has to already submit 75% of the award amount just to entertain his appeal, right? So what it does is, it filters out all the frivolous appeals, right? So any party wouldn't go just for the sake of appealing, because anyway he would have to submit 75% of the award amount. So a lot of time, the people, the MSME enterprises get their due amount without the party appealing, right? And section 24 is overriding effect, right? So this act has overriding effect over any other act, which is true for arbitration. So even if your transaction, or there is an agreement which says ki, which incorporates an independent arbitration clause between the parties, that the parties would go to arbitration, and this would be the seat, this would be the venue, and this court would have the jurisdiction. So even if it is there, and you are an MSME and you entered into a transaction post your registration into MSME, you still, irrespective of that arbitration clause, can go and avail the benefit of MSEFC, because this act has an overriding effect over the Arbitration and Conciliation Act, which is in 1996, and this was in 2006, right? Now coming to the next one. The next one is Section 138. Section 138, everybody knows, is dishonor of check for the reasons of insufficient funds. So if you have already a post-dated check through which you have secured your transaction money, the consideration that you had to get from the other party, you already have a post-dated check. So if that extended credit period expires, then you already have that check, right? And it is signed by the other party. You can just go and you can present that to a bank, and if that gets if it gets bounced due to the reason of an insufficient fund, then you can always proceed under this section, under criminal for criminal liability as well as civil liability against the issuer of check, right? So section 139 says ki whoever is holding the check always have this presumption that the check that they are holding was given to them in way to extinguish a liability, right? So if I have 5 lakhs of check from, let's say, UDYAMITA Helpline, and so the presumption would always say that UDYAMITA Helpline gave me that 5 lakhs of check in furtherance of extinguishing of their liability, which was towards me, right? So they had 5 lakhs of liability towards me, and they gave me the 5 lakh rupees check. So this is always the presumption. However, it is revertible. You can always go and revert that. Now the check was presented earlier, but I made the payment, so now I do not have any liability to pay. But then the presumption is always the first presumption is always in the favor of the check holder, but it is revertible. You can revert it with evidences and records of payment, right? Section 142 is cognizance of offense. Who can take cognizance of these offenses? The cognizance can be taken by either JMFC, Judicial Magistrate First Class, or the Metropolitan Magistrate, right? So they are the ones who are taking the cognizance of these offenses, right? Now, what is the procedure? So you prefer a complaint of that your check has been bounced, and you have given them a mandatory 30 days notice. So always keep in mind that you get a memo from the bank which states that your check has been bounced. This check has been bounced due to the insufficiency of funds. So at the date when you get that memo from the bank, within 30 days, you have to issue a notice to the opposite party saying that, see, your check has been bounced and you have to make this much payment to me. If you fail to make this payment to me, I'll go and I'll issue a complaint to the JMFC or Metropolitan Magistrate. And if you do not get payment within those 30 days, you can prefer a complaint before Metropolitan Magistrate or JMFC. So as I already stated, that it is a criminal offense, uh, bouncing of check due to insufficient funds, and action can be taken against both the enterprise and signatory of the dishonored check. So you can pick and choose from on whom against whom you want to proceed, right? Either it can be the enterprise on under whose name the check was issued, or it can be the signatory, the director who has signed the check on the behalf of the enterprise. So both of them can be individually and separately liable. So that is a good thing for the MSEFC. If they have the post-dated checks, this is the way forward, and this is all the provisions that you should take into account. Right now, coming to insolvency and bankruptcy code, as I stated, it has overriding effect. The MSMED Act had overriding effect over Arbitration and Conciliation Act, and this act is 2016. The same clause, the overriding effect is present in this code also, which uh, which gives the overriding effect of these provisions over MSMED Act also, because it was way back in 2006, right? So the overriding clause of this act would override the clauses of MSMED Act because it was passed earlier, right? So that is why whenever some party proceeds under insolvency and bankruptcy, under Section 14 of the Insolvency and Bankruptcy, all the other proceedings are stayed for the time being, and you can only join the proceedings under the insolvency and bankruptcy. So insolvency and bankruptcy is a very good way of recovering money. If your opposite party is a company or an LLP, please keep in mind that there are qualifying conditions for you to opt for this recovery mechanism. It is not a recovery mechanism per se. I would make you understand. इसमें क्या होता है कि आप हमेशा ऑपरेशनल क्रेडिटर्स होते हैं, क्योंकि MSMEs जो होते हैं, generally MSMEs are either manufacturers or service providers, and both by their definitions are covered under the operational creditor, right? Under the definition of operational creditors, there are only two creditors who can go and who can initiate insolvency and bankruptcy, which is called corporate insolvency resolution process against any corporate debtor. A corporate debtor is a corporate who is under the debt, right? And the debt has to be more than 1 crore rupees. If it is lesser than 1 crore, you cannot even go to the IBC, because the qualifying condition is that the debt should be more than 1 crore or 1 crore, right? So if these two conditions are met, the opposite party is corporate, and there is a debt of more than 1 crore of rupees, and the debt is not disputed, right? The other party has not disputed your amount prior to you invoking the insolvency and bankruptcy mechanism, then it is not disputed, right? So if it is not disputed, you can go and you can avail the proceedings of IBC. Now, you have to keep in mind that IBC is not always beneficial for operational creditor, right? Because whenever you go to IBC and CIRP is initiated, right, the other party is not able to pay you more than 1 crore of rupees, and NCLT accepts that company into insolvency. So if you have been the party who has initiated the insolvency and CIRP against that company, you would have to submit 2 lakh rupees so that the CIRP proceedings may go on for the time being, and your 2 lakh rupees, what you will submit for the CIRP to go on, would included in your claim, right? So please keep in mind that if you initiate CIRP against any company and you are successful in initiating the CIRP of any company, you would have to give 1.5 2 lakh rupees for the process to go on, and your 2 lakh rupees would be included in your claim, right? So this thing should be kept in mind, right? And I'll say ki the operational creditors are not made part of the committee of creditors. And so I would take you through the whole process of how IBC works, right? So if you have filed for CIRP of any company and it gets admitted into corporate insolvency resolution professional, then an IRP is appointed, insolvency resolution professional, interim resolution professional, I'm sorry, or resolution professional. So what happens is, this interim resolution professional assumes the power of the board of directors, because the board of directors gets suspended as soon as the company is admitted into insolvency and bankruptcy. Now, what IRP would do? IRP would go to the company. It would take control of all the assets, all the properties of the company. It would take control of the book of accounts, all the balance sheets, all documents of the company from the erstwhile directors, erstwhile board of directors, and then a committee of creditor is formed. A committee, what he'll do is he'll make a public announcement in a newspaper, two newspaper, in regional newspapers in vernacular languages and in English language, that saying ki this company has been admitted into insolvency and bankruptcy proceedings. CIRP has been initiated against this company. If any of you have claim against this company, you can please submit your claim to me. So what you'll do is, whatever claims did you have against that company which has been admitted into CIRP, you'll submit it to the you'll submit it to the IRP, right? Now IRP would form a committee of creditors now, basis on the all the creditors who have submitted their claim. So now the financial creditors are those creditors who have given cash and finances to the company. All the other creditors whose debts arises from provisions of goods or services are covered under the operational creditors. Even employers are covered under the operational creditors. But the banks, the financial institutions, NBFCs who give financial assistance in cash or finances to a company are covered under the financial creditor definition. So the financial creditors are the creditors which are included under the committee of creditors, right? So only and only financial creditors would constitute COC. The COC is the governing body of the CIRP company, the company which is being run by the IRP and COC. The COC is the board of directors, you can say, who now take effective, who now operate the company as a BOD, right? So they are the ones, they are the decision making authority, and IRP is there to oversee that the process is being followed in an appropriate manner, right? So what happens is ki whenever a committee of creditors is constituted, all of the creditors would go and submit their claims to the IRP. He would make a list of creditors that these are all the operational creditors, these are all the financial creditors, these are the amount which they are claiming. And now he'll do is he'll also make an information memorandum, right? I'm sorry that uh, I'll uh, I'll discuss section 14 also, which is moratorium. Moratorium is as soon as CIRP is initiated, all the other proceedings are stayed. All the other proceedings against that corporate debtor is freeze, except the criminal liabilities against the directors, right? So if if anyone is doing a civil suit against the corporate debtor, or anyone who was in arbitration already with the corporate debtor, then all of those things would be stayed, and all of those claims would now come before the IRP, and he would decide basis on the documents of the company that how much claims should be accepted and how much claims should be rejected, right? So that is what is moratorium is, right? And now I would say that the committee of creditors constituted. Now, the committee of creditors, what they do is IRP constitutes information memorandum. Information memorandum is the information of the company, assets, and the dues of the companies, right? And basis on that information memorandum, the prospective bidders who want to resolve the debts of the company in a manner and want to take over the company, right, are they express their interest in that information memorandum. They come up with scheme, they come up with resolution plan, saying ki these are the way in which we'll resolve the disputes, in which we'll restructure the debt. So a lot of time you'll see ki the operational creditors do not get a lot of recovery amount, because the only condition the SRA have to follow, the successful resolution applicant have to follow, that the proceeds should be adhered to the waterfall mechanism, which is under section 53. So in case of liquidation and liquidation of the company, if the company was not taken over by the any resolution applicant, and if it would have been liquidated, and in cases of liquidation, if the operational creditor would have gotten this much amount, the only condition is that in any resolution plan, that would be the least amount that the operational creditor would get. It cannot get lesser than that. So that would be the minimum amount as per the waterfall mechanism. If it says that the operational creditor would have gotten this much in the event of the liquidation, then that would be the minimum amount that the operational creditor would have to get in the successful resolution applicant, in the resolution plan. Let's say in liquidation amount, there was nothing which the operational creditor would have gotten under the waterfall mechanism. There would have been a nil amount, right? So even if that is the case, and someone submits a resolution plan, and if they do not give you any amount of money, then you wouldn't get any amount of money. So these things are called haircuts, right? So a lot of time you'd see a company a company is taken over by successful resolution applicants on large haircut, right? Because they can do so under waterfall mechanism, and COC is always constitutes of financial creditors, right? So they are not much bothered about the fate of operational creditor, whether they should get their debt from the resolution plan or not. They always see their interest first, and that is the reason, which is why it is not a very beneficial tool for recovery for operational creditors, right? So in cases where you know that the other party is a huge corporate house, it wouldn't go into liquidation or wouldn't go into CIRP just because of your debt. Then you can use it as a recovery mechanism, because you would know कि if you move to NCLT, there is nothing else that the corporate debtor can do except to settle the amount or to pay you the amount, right? So in that manner, it is very much beneficial for you. It is a quick disposal. It is a quick way of recovering money if you know that the other party wouldn't enter into CIRP. And please keep in mind that it depends on cases to cases whether you should move for MSME, whether you should move for IBC, whether you should move for civil recovery or other mechanism, right? So it always depends on the facts and circumstances of the case, right? So we'll come to the next slide now. Now, this is the resolution by way of alternate dispute resolution, online dispute resolution, arbitration and Conciliation Act. We already talked about Arbitration and Conciliation Act. There are certain sections that you should know. Section 9 is interim measures. So even if your arbitration tribunal has not been constituted yet, and you think that there is an interim measure you need to take, because if you had to wait for the arbitration tribunal to be constituted, it would be late enough, and you'd already suffer irreparable damages due to that delay. So what you can do is, before even constituting the arbitral tribunal, you can approach a court under section 9 for those interim measures, right? So that is covered under section 9. Section 11 is appointment of arbitrator. So if you have already agreed to a process through which you will appoint the arbitrator, the parties would appoint the arbitrator, and the one party is not adhering to the process that was agreed upon between the parties, then you can file section 11 before the court of law for the appointment of arbitrator. Section 16 is very much important, which says competence of arbitral tribunal to rule on its own jurisdiction. So even if you had issues, reservations regarding the jurisdiction of arbitration tribunal to hear your cases, all those jurisdictional issues you'll raise before the arbitral tribunal itself. So you cannot say ki, I do not think the arbitral tribunal has the jurisdiction, so I wouldn't go for arbitration, I would go to the court directly. That is not the case. Even if you have jurisdictional issues, you'd raise this in front of arbitrator, because section 16 says that the arbitrator is competent enough to rule on its own jurisdiction, right? And then section 13(4), as I already stated, it is for application for setting aside an arbitral award. There are very limited grounds on which arbitral awards are set aside. It is not dealt as a court of appeal where courts sit down and analyze the legality of the award, but they only see the award's validity on certain terms, limited terms, which is to say that if you have an arbitral award, there are very lesser possibilities that it would be set aside, until and unless it falls under those limited grounds which are there to set aside those awards, right? So how do you file your claim? How to file statement of claims and defenses? As I already stated, and I already informed you, that you file a statement of claim laying out all your claim and how those claims came out to be, the losses that you have suffered, all the evidences to substantiate your losses. And the same goes for statement of defense. Seat, venue and jurisdiction. The seat is key, whether which jurisdiction which courts of jurisdictions would have the jurisdiction to hear the cases of relating to the arbitration. That is seat. The venue is just the venue where the parties would conduct arbitration, and the jurisdiction is which courts would have jurisdiction for the cases related to the arbitration, right? So all of these are covered under the Arbitration and Conciliation Act. Now we'll come to the civil suit for recovery procedure. That is the classic way of recovering money. If you have, if there is, if the arbitration clause from your agreement is absent, you are not an MSME, or let's say that you entered into transaction and then you registered under the MSME. So if any disputes happen uh, uh, in transactions which arises prior to your registration, you certainly cannot go to MSEFC in those transactions, right? So you can go for Civil Procedure Code. You can institute a suit under Order 4 to recover your money. The summary suits is a class of suits where the opposite party is not given the chance to defend itself. The only chance that it gets on the first hearing is to convince the court that he should be given the chance to defend, right? So what are all the cases which should go in summary suits? So the cases which the cases in which the disputes are negligible. So if you have 1 crore of liability, or let's say 10 lakhs of liability, and the opposite party has accepted that liability, that yes, I have to pay this 10 lakhs to you, and it is not disputed at all, so you can just go to the summary suit, file your suit under this provision, Order 37, and the courts would see, and the courts would ask the opposite party that why he should be given a chance to defend itself. And if it is not convincing enough in the first hearing, then the court would not even give him the chance to defend, and it would hear you and pass an award, pass a decree, right? So that is only for the disputes which are not disputed, which are accepted, acknowledged, right? Benefits and shortcomings of the recourses under CPC. The benefits, that is a classic recourse. You can, if you have nothing to recover your money from, this is the way that you can go. And already the shortcomings, that you know that it takes a bit time, because it is before the civil courts of a certain jurisdiction, and civil courts, as we all know, runs at their own pace, right? And procedure and things to remember: the jurisdiction. You should always see the jurisdiction, how the CPC has conferred jurisdiction, that is under Section 18 of the CPC, right? So that you should keep in mind, that you are filing the case in appropriate jurisdiction, right? So it is where the defendant resides, or whether the cause of action arises, right? So always keep this in mind. And the summary suits, the last is summary suits under CPC. Order 37 is summary suits, as I already stated. Procedure and things to remember: as per 16 to 20, jurisdiction is 16 to 20. How better than a normal suit for recovery, as I already stated, that the opposite party doesn't get a chance to defend itself, so it is timely concluded. It is not as it does not take as much time as normal civil suit, right? Limitation for claims less than 3 lakhs. In case it exceeds commercial codes. So there are Commercial Codes Act also, which were introduced in 2015, right? For the commercial disputes which are more than 3 lakhs of rupees, you can just opt for Commercial Codes Act, which is almost as which is exactly a similar provisions to CPC. It's just that for commercial disputes, you have to take option into Commercial Codes Act. The provisions are similar. Everything is similar. The Commercial Codes Act only does only fixes the time limits on one party's obligation. So if you want to submit a written statement, you should do in a timely basis, or otherwise your right to defend would be closed. So all of these things were introduced to make ensure that the suits are concluded in a timely basis, right? So all of these things you can opt for basis whether your claim is commercial or not, or if it is less than 3 lakhs, then you should go for CPC. If it is more than 3 lakhs, you should see the commercial disputes definition in Commercial Codes Act, and if it falls within those definition, it is more than 3 lakhs, you should go for Commercial Codes Act, right? So I guess we have discussed all the provisions that were there for the recovery mechanism. Now we'll conclude it by substantiating on the quick tips and suggestions. Always mention applicable GST, IN, UAN, PAN numbers on invoice, registered office with address. So all of these things are mandated in law. If you'll see, if you'll see tax law, then how an invoice should be is already provided, that you should mention GSTIN, UAN, PAN numbers. If you have an MSME registration number, you should also mention that also, so that the other party cannot say at a later point of time that it never knew that you were an MSME, right? So all of these things, if you would mention in your invoice, in your work order, then it would be better, right? With your registered office address and everything. Invoices communication has to be recorded, managed, online way of communication. Always communicate. So always communicate in mail. Always communicate. Even if you're communicating in hard letters that you keep issuing to the other party, make sure that you record it in mail also, so that if it has to be checked, it can be checked, right? Cross-checked from your mail, right? Always have a pre-estimate of an amount which can be claimed as damages in case of delayed payments, right? So please insert liquidated damages clause in your agreement, under which you already decide that this would be the damages which the other party would be entitled for in case of breach of any of the conditions by one of the party, right? So all of these things you can consider. Always try to settle amicably. This is on the facts, situations, circumstances, amount in each case. The recourse has to be accordingly decided. Always try to safeguard interest by registering trademarks, design, mandatory compliances, and update statutory filing. I already stated all of this, that you have to be updated with your statutory filings, compliances, the forms which are required under law for you to fill, right, and for you to submit. Please create strategic assets like trademark, designs, patents, if it applies to your businesses. And always try to settle amicably. If you have a dispute, then please give the preference to mutual settlement, because your resources would be drained. If you opt for any of these dispute resolutions that we talked about, you'll have to take advice from professional, right? And they would have their own fees, right? So you always, it would be a burden for your financial resources in general. You would be your mental resources would be invested a lot of time in the disputes that you are dealing with. So all of these things are pretty much detrimental to our businesses, and all of these things can be avoided up to a greater extent if the other parties were to enter into talks and to settle the disputes mutually. So I think that's all for today's webinar. I think it would benefit you in somehow. Thank you.
Just request everybody, now we can go for question answers round, since Pratikji has just finished the session. So now whatever questions, queries you would like to ask, you can put it in the chat, or probably just raise your hand and we would introduce each one of you one by one. And Pratikji will try to, answer all the queries. And if so, also you want to have one-to-one talk, or there are issues which you would not like to discuss right now on the webinar, you can, we'll pin down the number in the chat. You'll have our email ID. One of the team members will get connected to you after the session, and we'll get you directly in touch with Pratikji. And you can have your individual meetings, or, you can discuss on call. If there's any issue you don't want to discuss it here right now, you can just write interested in the chat box, and one of our team member will get you connected. So I think we can just get started. Pratikji, it's okay if I can start with the question answer round?
Sure.
Okay. So first of all, we have Abdul Rahmanji. Would you like to ask the question right now? Can you unmute Abdulji, please? Evening, Abdulji, please ask your question. This is Amtex. Would you like to ask a question? Can I have one of the either asking the question, please? I see both of their mics unmute. Ravi ji, are you good to ask right now?
Hello, is it audible now?
Yes, you are. Yes. Very good evening. Please ask your question.
Okay, the question is, Actually, we have applied, since 2017-18, we were a medium scale MSME, and what happened is it has captured our data from the income tax portal. Now it is showing that we are not MSME.
Okay.
Recently we came to know that our turnover, our plant and machinery is less than 50 crore. Now we want to make it as not an MSME. How to amend our application?
That you'll have to seek from the MSME office, I would say, because these are things that they deal with specifically. Because
In
yeah,
regional office.
yeah. So you'll have to ask them ki what are all the procedure that you'd have to follow for your company to withdraw its registration from MSME, or to upgrade your registration, or to downgrade your registration from micro to, let's say, small, or from small to micro. So all of these depends on your ITR of the
Regional office.
previous years and the investment made in plants and machinery. But if there is any issues regarding that, if your registration is cancelled due to certain reasons which are
No,
not known to you, you can go
no,
always, you
actually,
can always, sorry,
100 and sorry, our turnover is 1500 crore, but
your turnover is 1500 crores now.
yes, in that nearly 1400 crore is export.
Okay, so as per the definition clause also, you are not eligible for to be registered under the MSME now, right? So now you can
Because our
intimately,
turnover,
sorry.
no, sorry to interrupt, our
Huh?
turnover is 1500 crore, but our export itself 1400 crore. Only 1000 crore is our local sale.
That is not
100
classified
crore is
under
our
the
local sale.
MSME. Please understand that even if you are making exports or import, that is not there in the classifying definition, right? So कि वो ये तो नहीं कहता ना कि आपका एक्सपोर्ट अगर 50 करोड़ के ज्यादा है और इंपोर्ट इतना है तो आप इसमें रजिस्टर करेंगे, ये
No,
सिर्फ
there is
बोलते हैं
an
कि
option
टर्नओवर
into
आपका कितना है,
MSME application. Sorry to
आपका
interrupt, sir, once again. While filing the application, it will disallow the export and the rest of the it will calculated as an turnover.
यू आर सेइंग कि आपका जो एक्सपोर्ट है वो उसको हटा दिया जाता है इन
Yes,
इन इन
while
टेकिंग
filing the application.
इन टेकिंग। तो अगर ऐसा भी है, अगर मान लेते हैं कि अगर ऐसा भी है और ऐसा कंडीशंस है आपके उसमें, तो आपको ये देखना पड़ेगा कि आपका अगर जो आपके साथ प्रॉब्लम्स आ रही हैं वो आपको एमएसएमई के जो मेंबर्स हैं उनको बतानी पड़ेंगी, क्योंकि ये जो रजिस्ट्रेशन का
Okay,
इश्यूज आ रहा है आपके साथ, जो आपको रजिस्ट्रेशन का इश्यूज आपको सेटल करना है, वो आपका बस और बस एमएसएमई के ऑफिस से ही हो पाएगा, क्योंकि
okay,
दे
regional
आर द
office.
विद द पावर टू अमेंड इट, राइट?
Yes,
यस।
that is correct. They have the power to amend. Yes,
यस। सो
that's
अगर
correct.
आपका एक्सपोर्ट वाला भी प्रॉब्लम है कि आप बताना चाहते हैं, उनको क्लासिफाई करना चाहते हैं कि हमारा टर्नओवर ऐसे कंप्यूट नहीं होना चाहिए, जैसा कि आपने मुझको अभी खुद बताया कि आपका एक्सपोर्ट वाला जो वो है उसमें लिखा है कि एप्लीकेशन उसमें कंसिडर नहीं करेगी, तो आप ये चीज उनको बता सकते हैं कि ये ऐसा है यहाँ पे लिखा हुआ, और इस बेसिस पे हमारा ये क्लासिफिकेशन में होना चाहिए या फिर नहीं होना चाहिए। तो जो आपका
Okay,
इश्यूज है वो आप वहाँ के मेंबर्स से जब बात करेंगे तो वो आपका डील कर पाएंगे अच्छे से।
okay, sir. Thanks a lot.
यस।
Who do we have now? Yes, please ask your question, Amtrix. Mohit ji, please ask your question.
Hello, am I audible?
Yes, sir, you are. Very good evening.
Good evening. Yes, previously there was Udyam Aadhar, Udyog Aadhar. So we have been an MSME since 2015. Now, debtor is of around 40 lakhs is not been able to make payment. So I think it falls. Udyog Aadhar is recent, but Udyam Aadhar, I think. Udyam Aadhar is recently formed. So can we make a claim in this MSME forum for the previous claims?
Can you repeat his question for me, Sonia? I couldn't hear it properly.
Yeah. See, previously there was Udyog
Udyog,
Aadhar.
yes.
So we are MSME since Udyog Aadhar.
Okay.
So during this time we have an debtor of around 40 lakhs, which we would like to recover. So now MSME Act has come very recently, I suppose. So
In 2005, sir. It's been now 20 years.
okay. So I
Yeah.
think we are eligible for.
Yes, you're eligible for making your application to the MSME if your registration, you're saying, as you're saying, that you have always been had Udyog Aadhar and now the
Yes.
Udyam registration has come. So you have also transferred it to Udyam
Yes.
registration. Then you can always make your application reference before the MSEFC. Megha would help you out with it. If you have not issued any legal notices to the opposite party, I would suggest you to issue a legal notice first, a reminder notice again, because अगर आप ऑलरेडी डिस्प्यूट में घुस जाते हैं तो आप मेरे हिसाब से आपको पहले उनको एक ऑप्शन देना चाहिए कि अगर देखो अगर आपको पे करना है तो यू पे इट इन विद इन दीज टाइमलाइंस, अदरवाइज विल मूव will invoke the recovery mechanism, legal recovery mechanism, whatever is available to me. So a lot of times मैंने देखा है कि आपके लीगल नोटिस का रिप्लाई आ जाएगा उधर से, तो आपको पहले ही फर्स्ट हैंड में पता चल जाता है कि आगे वाले को कहना क्या है, तो आप आप उनके रिप्लाई से अपना केस स्ट्रेटेजाइज कर सकते हैं अगर वो डिस्प्यूट कर रहे हैं तो। और अगर मान लीजिए वो बोलते हैं कि नहीं मुझे पैसा देना है, और अगर आपको पैसा दे भी देते हैं तो वेल एंड गुड, आपको फिर एप्लीकेशन करने की जरूरत नहीं थी और ये सब आपको विड्रॉ नहीं करना पड़ेगा एप्लीकेशन बाद में। तो ऑलवेज गिव अ चांस टू द ऑपोजिट पार्टी, क्या पता कि आपको डिस्प्यूट्स ना करना पड़े, समझ रहे हैं? तो इसके लिए हमेशा लीगल नोटिसेस देने की मैं बात करता हूँ कि हो सकता है कि आप लीगल नोटिसेस इशू करेंगे, यू इशूड टू द ऑपोजिट पार्टी द लीगल नोटिस एंड द ऑपोजिट पार्टी पेज in reality. So it's a win-win, right? Because you just issued a legal notice and you got your payment. So first issue a legal notice, remind them that if they do not pay, you'll approach the MSEFC, and if they do not pay, approach the MSEFC, and the MSEFC would conclude your case within 1 year, preferably. एक साल से ज्यादा नहीं लगाते generally MSEFC वाले.
Okay, thank you.
Who do we have next?
Yeah.
Dinesh ji, would you like to ask? Dinesh Sharma ji, please ask your question. We have Sasikala ji. Would you like to ask, please?
Hello.
Good
Hi.
evening. Please ask your question.
Okay, madam. After we done the payment, what is the procedure for us?
So you already gotten an award, you're saying?
Sir?
You're saying you have already gotten an award from MCFC. What did you say? Can you please repeat?
Delayed payment.
After we are complete the delayed payment recovery.
मतलब आप बोल रहे हैं कि when you make an application, जब आप एप्लीकेशन डाल देते हैं कि आपका डिलेड पेमेंट हो गया है, उसके बाद क्या होता है?
Yes, sir.
हाँ, तो उसके बाद जैसे कि मैंने आपको पहले बताया कि उसके बाद जो है वो ऑपोजिट पार्टी को नोटिस देती है MSEFC कि हमारे पास ये केस आया है और वो आपसे इतना पैसा मांग रहे हैं, आपको कुछ बोलना है तो आप बोल सकते हैं, नहीं तो आप ये पैसा पे कर सकते हैं। तो अब ऑपोजिट पार्टी के पास दो ऑप्शन है, या तो वो आपको पैसा पे करेगी या तो वो डिस्प्यूट करेगी। तो अगर वो डिस्प्यूट करेगी, बोलेगी कि नहीं मेरे हिसाब से इतना पेमेंट नहीं बनता है इनका, और ये पेमेंट ये लोग गलत बोल रहे हैं, इनके अकाउंट्स में दूसरा है, हमारे अकाउंट्स में दूसरा है, तो वो भी जो भी उनको डिफेंस देना होगा वो देंगे आपको। तो MSEFC वाले वो आपको आगे बढ़ा देंगे, बोलेंगे कि ऑपोजिट पार्टी को ये कहना था आपके एप्लीकेशन के फर्दरेंस में, फिर आप MSEFC को बोलेंगे कि वो अपना प्रोसीडिंग्स के साथ आगे बढ़े, दैट इज कंसिलिएशन प्रोसीडिंग्स फर्स्ट। तो कंसिलिएशन प्रोसीडिंग स्टार्ट होंगी जब दोनों पार्टीज को बुलाया जाएगा साथ में, और दोनों पार्टीज को बोला जाएगा कि आप लोग कंसल्ट करके म्यूचुअली सेटल कर दीजिए। तो अगर दोनों पार्टीज मिलके एक कंसेंसस पे आ जाती हैं, सेटल कर देती हैं, या फिर एक पार्टी बोलती है कि नहीं मैं आपको पे कर दूंगा, हमें आगे जाने की जरूरत नहीं है, आप मुझे बस थोड़ा सा टाइम दे दीजिए, मैं आपको पे कर देता हूँ। तो वो सारा जो चीज है कंसिलिएशन में, वो एक सेटलमेंट अग्रीमेंट बनता है, उसमें सारी अंडरस्टैंडिंग लिख के दोनों पार्टी साइन कर देती हैं, और फिर एमएससीएफसी से केस खत्म हो जाता है। फिर आपके पास वो सेटलमेंट अग्रीमेंट आ गया जिसमें ऑपोजिट पार्टी ने माना है अनइक्विवोकली कि आपको ये पेमेंट वो इस मैनर में करेगा। तो अब मान लीजिए कि आपका कोई सेटलमेंट हुआ ही नहीं कंसिलिएशन में, तब फिर वो आर्बिट्रेशन में चला जाता है। तो आर्बिट्रेशन में क्या होता है कि आर्बिट्रेशन में जब वो जाएगा तो आप अपना एक आर्बिट्रेटर अपॉइंट होगा, न्यूट्रल आर्बिट्रेटर, उसको आप जाके बोलेंगे स्टेटमेंट ऑफ क्लेम में कि ये सब मेरा क्लेम है, आपका 20 लाख का है, 40 लाख का है, तो आप उसको बताएंगे कि कैसे आया ये क्लेम, इसमें कोई और एडिशन है, कोई एक लॉस है जो आप एक्स्ट्रा मांग रहे हैं तो आप वो मांग सकते हैं। आप उसको सब्सटैंशिएट करेंगे एविडेंसेस के साथ कि ऐसा ऐसा एविडेंस है जो कि मेरा लॉस दिखाता है कि मुझको इतना, मैंने इनको इतना सप्लाई किया और इन्होंने मुझको अभी तक पैसा नहीं दिया है, ना ही अभी तक आज तक डिफेक्ट कोई पॉइंट आउट किया। तो आप ऐसे प्रूफ करेंगे कि आपको 40 लाख रुपए मिलने चाहिए या फिर जितना भी आपका ड्यू है मिलना चाहिए। ऑपोजिट पार्टी क्या करेगी, ऑपोजिट पार्टी अपना स्टेटमेंट ऑफ डिफेंस देगी, अपने अपने एविडेंसेस लाते हैं लोग। तो इन सब के बाद जब आर्बिट्रेटर सुनता है, उसके बाद उसको लगता है कि नहीं आपको इतना पैसा मिलना चाहिए, तो वो अवार्ड पास कर देगा। तो अवार्ड पास कर देगा, उसमें ये लिख देगा कि ये पार्टी को इतना पैसा मिलना चाहिए, इतना इंटरेस्ट मिलना चाहिए। और जब ये आपके पास अवार्ड आ जाएगा, तो फिर मान लीजिए ऑपोजिट पार्टी के पास दो ऑप्शन है कि या तो वो पे कर दे क्योंकि वो ऑलरेडी हार चुका है केस, या तो वो अपील भी करेगा। तो 75% उसको पहले ही जमा करना पड़ेगा अपील करने के लिए, समझ रहे हैं, जो अवार्ड अमाउंट है। और अगर मान लीजिए वो फिर भी पे नहीं कर रहा है, तो आप
75
उसको एग्जीक्यूट करा सकते हैं।
I can't get you. Can you say the last word in English?
आप मैं ये बोल रहा था कि जब आपके पास अवार्ड आ जाता है, आर्बिट्रेटर ने दोनों पार्टी को सुन के, उनको लगा कि आपका पैसा इतना है, आपका पैसा इतना बनता है इस ऑपोजिट पार्टी से, तो वो आपको अवार्ड पास करके दे देते हैं उतने पैसे का, कि आपको इतना पैसा ऑपोजिट पार्टी से लेना है। तो अब आप ऑपोजिट पार्टी को बोल सकते हैं कि आपका अवार्ड आ गया है, आप मुझको पेमेंट कर दीजिए। तो वो एक चीज कर सकता है कि वो अपील कर सकता है एमएससीएफसी का अवार्ड। तो अगर वो अपील भी करता है, तो उसको 75% जो आपका अवार्ड मनी है वो कोर्ट को जमा करना पड़ेगा, अगर वो अपील करता है तो वो।
No, can you say in English this last?
सॉरी।
Can you say in English the last word? I can't.
हाँ, मैं बोल रहा हूँ कि उसको 75% जो है ना, आपका अवार्ड में जितना आपका पैसा आपको बोला गया था कि आपको इतना
In
लेना है।
English, sir, please.
Oh, English. Okay, sorry. So if in award money, it was stipulated that you had to get this much of amount from the opposite party, right? So what the opposite party would do if he wants to appeal that award, that no, I do not agree with this award that you are having, that I have to pay 50 lakhs to you or 40 lakhs to you. So for making that appeal also, he'll have to submit 75% of the award money, which is, let's say, if you had an award amount of 40 lakh rupees, so for maintaining an appeal against your award, he'll have to submit 75% of 40 lakh to the court. So then only his appeal would be maintained. समझ रहे हैं आप? So that is one benefit to you. And even if he's not paying your amount, you can go for execution proceedings in your civil courts to execute the decree which has been passed by the MSCFC, in which you'll reflect the assets of the corporate debtor. You'll say that these are all the assets of the corporate debtor which can be auctioned off or sold off to recover my disputes. And then in execution proceedings they would get a notice that why aren't you paying them, and if they do not pay, then their assets would be taken hold of and they would be auctioned and they would be paid to you. The proceeds would be paid to you.
So we need to fix the advocate, or you are helping us to in court.
So for the process, right, for delayed payment proceedings, so you can get in touch with Megha if you want our assistance. We would be love to assist you. Not a problem.
Okay.
I'm just leave interested in the chat box. We'll have somebody from the team to get you connected through Mr. Pratik. Okay, Sasikala ji? Okay, can we have some the next person, please? Is it Mr. Dinesh ji? Would you like to ask now? Sunil ji, good evening. Please ask your question. Ji, would you like to ask, or is it Harish Ji? Can you unmute, please? Harish Ji, please ask your question. Ji, would you like to just have a look in
Hello.
the chat section? There are a few questions there.
Yes, yes, yes.
Hello.
Please go ahead.
Meanwhile,
Yes.
yeah, meanwhile,
Yes.
Sonia, can you hear me?
yes, Harish Ji, please ask your question. Yeah.
Yes. Yes. Ma'am, I registered Samadhan, MSME Samadhan. Okay, there was registered, but there's a counseling saying your case is not converted to by converted. It's a due court.
Okay.
What?
Sorry.
Harish Ji, your voice is breaking. Can you come towards the network area, please?
Yes, 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 yes.
So
Okay,
your reference. Sorry. Yes.
yes, सर मैंने रजिस्टर कर दिया है समाधान में,
हाँ,
लेकिन ये है कि आपका अभी कन्वर्ट नहीं हुआ एप्लीकेशन ड्यू
ठीक है,
कोर्ट और
ठीक है।
यू मे कॉन्टेक्ट टू MSME, व्हाट दैट मीन्स?
हाँ, आप जब भी रेफरेंस फाइल करते हैं ना, कोई भी आप रेफरेंस एप्लीकेशन जब फाइल करते हैं, तो
जी।
आप सर्टेन डॉक्यूमेंट्स देते हैं उनको। उसमें
जी,
परचेज
जी,
ऑर्डर
सर।
होता है, उसमें इनवॉइसेस होता है ना? तो वो लोग सर्टेन चेक्स देखते हैं कि आपका
जी।
वर्क ऑर्डर कहीं आपके रजिस्ट्रेशन के पहले का तो नहीं है, आपके इनवॉइसेस आप ट्रेडर तो नहीं है। तो ये सारी
जी।
चीजें वो लोग थोड़े-थोड़े चेक्स देखते हैं। उसके बाद वो उनका अपना प्रोसेस है। अपने MSMEs के स्टेट में अपना टाइम लेते हैं वो केस को कन्वर्ट
अच्छा।
करने के लिए। बट ये प्रोसेस है, वो आपका केस कन्वर्ट हो जाएगा अपने आप।
ओके, ओके,
हाँ, हाँ। वो
थैंक
सबके
यू।
साथ ही होता है। वो आपको थोड़ा
Okay.
टाइम लगेगा, दे विल कन्वर्ट योर केस, नो प्रॉब्लम।
राइट, थैंक यू।
Can I ask a question?
Please, yes. Deep Ji, please ask.
Okay.
झाले काम तर कामात आहो. बर बर हे बोलो लो पेजगंवर सेवाच्या गाडी थांबली.
I'm sorry, you're not clear, Sandeep Ji.
Yeah. Sorry. I'm just asking. Hello, how are you?
I'm good,
Sir,
Sunil.
मेरा एक क्वेश्चन था.
हाँ,
7th of November. Actually, I'm residing in Delhi. और मैंने किसी बाहर की मेरी ओवरसीज ओवरसीज आउट ऑफ दिल्ली किसी पार्टी के साथ में ना 7 नवंबर को एक बिजनेस डील किया. एन अमाउंट इज समवेयर अराउंड 7 लाख रुपीस.
ओके।
तो उनके पास से पेमेंट नहीं आया सर. आई एम ए माइक्रो MSME माइक्रो.
हाँ,
तो उनके पास से पेमेंट नहीं आया. डिस्पाइट रेगुलर हम लोग कन्वर्सेट कर रहे हैं, कॉल कर रहे हैं, चैट कर रहे हैं व्हाट्सएप पे, लेकिन अभी तक वो उनके प्रोमिसेस गोइंग बट लेकिन कुछ हो नहीं रहा है. तो फाइनली मैंने अभी आपका ये मेरे पास मेल आया था उद्यमिता का, तो मैंने उसके अंदर एक क्वेरी डाली थी. तो आपके यहाँ से एक मैम है मेघा मैम, उनसे मेरी फिर बात हुई थी. उन्होंने कहा सर आप एक बार सारे डॉक्यूमेंट्स हमें शेयर करें. तो मैंने वो सब डॉक्यूमेंट्स शेयर करे उन्हें. तो अब मेरे को सर ये समझना था, उन्होंने मुझे ये कहा है कि सर आप इसमें रजिस्टर करा सकते हैं एंड दैट कॉस्ट मी अराउंड 10,000 रुपीज प्लस 1800 GST. तो बोले सर हम फाइलिंग कर देंगे. लेकिन मैं अभी आपकी बात सुन रहा था सर, आपने एक जगह कहा कि एक बार आपको पहले लीगल नोटिस देना चाहिए. अभी तक मैं लीगल नोटिस के कोई प्रोसेस से नहीं निकला हूँ. मैंने जस्ट खाली उनको एक अपनी तरफ से एक मेरी कंपनी के लेटरहेड के ऊपर उनसे क्लेम खाली किया था कि सर आपकी तरफ मेरा पेमेंट ड्यू है.
सर्व्स इनफ फॉर यू. मैं ये
Okay.
नहीं बोलता हूँ कभी भी कि लीगल नोटिस जब आप दें तो आप हमेशा कोई एक प्रोफेशनल के लेटर हेड पे ही दे, लेकिन एसेंशियली लीगल नोटिस वही होता है व्हेन एन एडवोकेट इश्यूज इट. बट देन इट इज नॉट अ प्रॉब्लम इफ एडवोकेट इज नॉट इशूइंग इट. अगर आप खुद भी इशू कर रहे हैं और ये बोल रहे हैं कि विल गो फॉर लीगल रिकवरी मैकेनिज्म इफ यू डू नॉट पे अस विद इन दिस टाइमलाइन.
सर सॉरी टू इंटरप्ट यू सर, मैंने उसमें ना कहीं भी ये नहीं लिखा था कि मैं कोई लीगल रिकवरी मेथड ऑब्टेन करना चाहता हूँ या ऑब्टेन करूंगा. अभी तक मैंने वो सिंपल ही लिखा था कि भाई वी ऑन बिहाफ ऑफ आवर कंपनी सो एंड सो, भाई आपकी आउटस्टैंडिंग ड्यू है तो आप प्लीज को पे कर दे. जस्ट सिंपल एक सिंपल एक प्लेन एक लेटर ही मैंने भेजा.
आप अभी ऐसा करिए, आप आज ही उनको एक मेल लिखिए कि वी हैव वेटेड इनफ फॉर द पेमेंट एंड वी आर इन द प्रोसेस ऑफ we are in the process of filing the appropriate legal recovery mechanism that we have, and as a last resort, we are giving you 10 days of time to make this payment. If you do not make this payment, we'll go and we'll file the reference application before MSEFC.
एंड सर इसमें मैंने एक बात और पूछी थी मेघा जी से, उन्होंने कहा कि सर आपके पास में कोई ऑर्डर, क्या बोलते हैं आप लोग, प्री ऑर्डर कुछ है क्या आपके पास? आई जस्ट कांट रिमेम्बर द वर्ड एग्जैक्टली। मैंने उनसे ये कहा था कि देखिए हमारे पास में ना कुछ ऑर्डर नहीं होता है, सिंपली क्या है, देखिए बेसिकली वी आर इन ज्वेलरी इंडस्ट्री, हमारे पास होता है क्या है, हमारा रेडी स्टॉक होता है, हमने जाकर के प्रोस्पेक्टिव बायर को शो कॉस्ट किया, उसने उसमें से बोला हाँ सर ये मेरी पसंद का है, ओके हुआ, एंड देन वी विल इशू द appropriate invoice, what you said, e-invoice is applicable on us.
बिल्कुल।
इन सब डॉक्यूमेंट्स के बेसिस के ऊपर कभी अगर मान लीजिए एमएसएमई में मुझे कोई केस करना भी पड़े फर्दर, तो ये सब इनफ है, सफिशिएंट डॉक्यूमेंट्स है मेरे पास या नहीं है?
नहीं, इनफ है, लेकिन अगर आपके पास और एग्रीमेंट होना जिसमें टर्म्स एंड कंडीशंस लिखे होते हैं, जैसे कि परचेज
सर
ऑर्डर,
मेरी इनवॉइस के ऊपर मेंशन है सर 60 डेज देयर।
हाँ, तो ये सब ठीक है, अगर आपके पास है तब तो वेल एंड गुड। अगर आपको लगता है कि और ज्यादा कंडीशंस की जरूरत है नहीं आपके सच बिजनेसेस में, तो जितना आपने टर्म्स एंड कंडीशंस लिखा है आप खुद सोच के इसको और बढ़ा सकते हैं, थोड़ा बड़ा कर सकते हैं इनवॉइस अपना और टर्म्स एंड कंडीशंस डाल के, तो इट वर्क्स वेल, नो प्रॉब्लम।
नॉर्मली सर हमारे एक्चुअली इंडस्ट्री में ना यही एक टर्म चलती है कि बेसिकली हम लोग है ना, जो हमारी आपस में जो भी हमारा डिसाइड होता है वो टर्म्स हम हमारे इनवॉइस के ऊपर मेंशन कर देते हैं कि भाई ये टर्म्स है, एंड बाय दैट टर्म्स नॉर्मली सर हम लोगों पे पेमेंट आ भी जाता है टाइमली।
बिल्कुल बिल्कुल। और
क्योंकि
अगर आपके बिजनेसेस में ऐसे कोई दिक्कत नहीं आ रही है तो फिर ऐसा जनरल तो देखिए, ऐसे डिलेड पेमेंट के इश्यूज तो सारे ही बिजनेसेस के साथ होते हैं, भले वो छोटे हो बड़े, समझ रहे हैं? तो आप इसको बंद नहीं कर सकते एकदम पर से, बट देन अगर आपके टर्म्स एंड कंडीशंस है तो आपको अभी दिखेगा, जब आप एमएसएमई जाएंगे तो आपको दिखेगा कि आप अपनी अंडरस्टैंडिंग कैसे एग्जैक्टली प्रूव कर पा रहे हैं, समझ रहे हैं?
इसमें ये और मैं पूछना चाह रहा था सर, मान लीजिए इन एनी केस अगर मुझे एमएसएमई को अप्रोच ही करना पड़ा, तो इनिशियली जो यहाँ पे मेंशन किया गया सर 10,000 प्लस 1,800 जीएसटी व्हाटएवर, सो इज दैट द ओनली मनी आई हैव टू पे, और इससे कुछ ज्यादा मुझे फर्दर पेमेंट करना पड़ता है सर इसके?
This is for the filing purpose that I charge you. This is my charge for filing of the reference application. Right? तो अगर आप फाइल कर देते हैं, मैं आपका फाइल कर दूंगा, उसके बाद 6 महीने बाद एक्चुअल प्रोसेस शुरू होता है, ठीक है? क्योंकि आप जब केसेस फाइल करेंगे तो जैसा अभी एक और क्वेश्चन पूछा था हमसे कि अभी हमारा केस कन्वर्ट नहीं हुआ है, तो पहले वो स्टेज में जाएगा, वो लोग चेक करेंगे, फिर आपका केस कन्वर्ट करेंगे, फिर आपका कंसिलिएशन होगा। तो कंसिलिएशन तक में तो आपको एडवोकेट की जरूरत है, आप अपना देख सकते हैं कि आप खुद भी कर सकते हैं या फिर एक आपको एडवोकेट चाहिए तो आप उसके थ्रू भी कर सकते हैं, बट दैट इज ओनली फॉर द फाइलिंग चार्जेस। अगर आपको आर्बिट्रेशन में मेरी और हेल्प चाहिए होगी तो फिर दैट वुड इंटेल अनदर एडिशनल चार्जेस फॉर माय अपीयरेंसेस।
एक्सपेंडिचर क्या पड़ जाता है सर?
एक्सक्यूज मी, लेकिन आप मिस्टर सुनील जी को अनम्यूट कर देंगे प्लीज, म्यूट कर देंगे प्लीज। सुनील जी की भी आवाज आ रही है, संदीप जी की भी आवाज आ रही है, इसलिए
हाँ, तो मैं आपको बता रहा था कि इसका खर्च जो पड़ता है वो केस टू केस बेसिस पे डिपेंड करता है, तो मुझको ना आपके डॉक्यूमेंट्स एक बार देखने पड़ेंगे कि क्या है आपके डॉक्यूमेंट्स, क्या नहीं है। एक बार
मैं एक्चुअली सर आपको मेल कर चुका हूँ, आप प्लीज सर चेक करके मुझे डेफिनेटली रिवर्ट कर
मुझको आ जाएगा। अगर आपने भेज दिया है मेघा को, देन शी विल फॉरवर्ड मी।
सर मेघा जी ने भी भेज रखा है और आपका ये उद्यमिता हेल्पलाइन पे भी गया हुआ है सर,
वो मेरे पास आ जाएगा, यू डू नॉट टेक टेंशन।
मैं आपके सजेशन से मैं एक बार उनको आज उनको एक लेटर दूसरा इशू कर देता हूँ, अगर उसके बाद भी अगर अराउंड आई विल वेट अनदर 15 डेज, नहीं हुआ तो फिर मैं आपसे कांटेक्ट करूंगा सर। आई विश सर अगर आप अपना पर्सनल मुझे नंबर अगर मुझे मेल पे शेयर हो जाए तो आई विल टॉक टू यू डायरेक्टली।
मेघा वुड डू दैट, नो प्रॉब्लम।
थैंक यू बॉस, थैंक यू बॉस, थैंक यू वेरी मच बॉस, थैंक यू। And I'm leaving this webinar. Thank you very much for your time and for your effort. Thank you. Thank you.
Thank you, Sandeep ji, for joining us. Thank you so much.
Thank you, ma'am. Thank you, ma'am.
Can we have Sunil ji now? Sunil ji, now you can ask your question, please. Good evening, Sunil ji. Please ask your question. Somebody from Nilu Equipment. Is it Sunil ji? Are you there?
Hello.
Is it Sunil ji? Yeah. Good evening, Sunil ji. Please ask your question. Please ask your question, Sunil ji. हाँ जी, please, you may ask your question, please.
Hello.
Yes, Sunil ji. Hello. Can you hear me, Sunil ji? There's an issue at your network area. You can just write the question in question answers or chat section and we'll get you answered. Please ask your question, Sunil ji. We have Mr. Ansari ji also. You can unmute Ansari ji meanwhile. And he can ask his question, please. There seems to be some network issue at Sunil ji's end. He's trying to connect, but he's not able to. And I'm just waiting if Mr. Ansari would like to ask a question. Otherwise, we can just run across some questions in the chat box.
Sure.
Yeah.
We'll wait for Ansari ji once.
If you want
question.
Unmute Ansari ji. Karthik, are you there? I think Sunil ji is back. If you can unmute him and he's audible enough and he can ask his question quickly. My IT team help Sunil ji and Ansari ji ask their questions.
In the meanwhile, I'll start reading the questions from Q&A.
I think that's fine, Pratik ji.
So if client is, yeah, Sunil ji, you had question? So the first question is, if a client is under NCLT, how to claim payment from them? So I suppose if an attendee is saying if a client is under NCLT, he's under NCLT for CIRP processes. And if the CIRP processes has been accepted and been admitted by the NCLT and the company is now under the corporate insolvency resolution process, then you should go to the CIRP IRP, which has been appointed under that CIRP, interim resolution professional or resolution professional. Their emails are on public domain, and you can submit your claim in a particular format, which is there on the IBBI website. We can help you with that. You can fill that form, you can fill your claim, and you can submit to the RP. So that is the way of doing it. So I hope I'm clear. And the next question is, what is the territorial jurisdiction to file the MSME case? So if you are having the delayed payment issues and you are an MSME entity, so the jurisdiction, the territorial jurisdiction where you are registered would be the MSME jurisdiction, which would have the jurisdiction to deal with the MSME reference cases. So if you're an MSME registered in Delhi, you would go and you file your reference case before MSEFC Delhi. So that is how the jurisdiction is determined in MSEFC, right? The third one is, मेरा कंस्ट्रक्शन बिजनेस है और 2 क्लाइंट्स के पास मेरा 2-2 लाख का पेमेंट पेंडिंग है, मेरे पास अग्रीमेंट भी है, मैं कैसे रिकवर कर सकता हूँ? So if he was always registered as a MSME unit, अगर माइक्रो स्मॉल यूनिट थे वो ऑलरेडी, वो कंस्ट्रक्शन बिजनेस, वो दो क्लाइंट के ट्रांजैक्शन करने से पहले, तो वो MSEFC में अपना रेफरेंस क्लेम फाइल कर सकते हैं. अगर वो भी नहीं है तो आपको अग्रीमेंट में देखना पड़ेगा कि आपके अग्रीमेंट में डिस्प्यूट रिजोल्यूशन क्लॉज है कि नहीं है. अगर आर्बिट्रेशन क्लॉज है तो आप सिर्फ और सिर्फ आर्बिट्रेशन कर सकते हैं. अगर आर्बिट्रेशन क्लॉज नहीं है, कोई डिस्प्यूट रिजोल्यूशन क्लॉज नहीं है, तो फिर आपके पास है जो क्लासिक वे ऑफ रिकवरिंग मनी है, सिविल सूट फॉर रिकवरी और फॉर समरी सूट फॉर रिकवरी. तो ये है. if an international customer defaults on payment, are there any special provisions or support we can get as MSME? I do not think it applies to foreign jurisdictions, जहां तक कि मुझे पता है. But anyway, I'll get confirmed on this, because this is something which is not in very black and white area. It is still under the gray area. I do not think that the foreign companies can be brought under the MSME jurisdiction, but मेरे हिसाब से कि नहीं है. आप इंटरनेशनल जो प्लेयर्स हैं उनको एमएसएमई के डिफॉल्ट मैकेनिज्म में नहीं ला सकते. आपको नॉर्मल प्रोसीजर में जाना पड़ेगा, नॉर्मल सूट करने पड़ेंगे, या फिर नॉर्मल अदर डिस्प्यूट रिजोल्यूशन मैकेनिज्म है तो वो देखना पड़ेगा. मेरा कंस्ट्रक्शन बिजनेस है, 2 क्लाइंट्स, ये सेम क्वेश्चन है. आवर डिस्ट्रीब्यूटर इज नॉन एमएसएमई, हाउ टू रिकवरी और डिलेड पेमेंट? इट इज नॉट, इसका कोई भी कंडीशन ये नहीं होता है कि आप जिससे रिकवर करना चाहते हैं पैसे वो भी एमएसएमई हो. आपका एमएसएमई होना जरूरी है. अगर आप एमएसएमई हैं और आगे वाला गवर्नमेंट ऑफ इंडिया भी है, कोई एक डिपार्टमेंट भी है, इररेस्पेक्टिव वो पार्टनरशिप है, सोसाइटी है, ट्रस्ट है, कंपनी है, तो वो इररेस्पेक्टिव है. अगर आप एमएसएमई हैं, आप रजिस्टर्ड थे पहले से, ट्रांजैक्शन में एंटर होने के पहले से रजिस्टर्ड थे आप, और उस ट्रांजैक्शन में कोई डिस्प्यूट हुआ है, आपका पेमेंट स्टक है, तो आप एमएससीएफसी जा सकते हैं. आपके डिस्ट्रीब्यूटर का एमएसएमई होना ना होना इससे कोई फर्क नहीं पड़ता. तो could you send us what is the procedure after we done the payment? Okay, so if you had already a delayed payment case and you already paid, तो आपको अगर आपको एमएसएमई समाधान चलाना आता होगा, जहाँ पे फाइल करते हैं केसेस और एवरीथिंग, तो यू कैन आस्क योर एडवोकेट कि विड्रॉ योर केस. वहां पे एक ऑप्शन आता है विड्रॉ करने का केस आफ्टर द पेमेंट हैज बीन मेड, तो आप उस बेसिस पे विड्रॉ कर सकते हैं. I have applied on Samadhan portal, but still there will not be any hearing kept before authority. It takes some time. It takes some time. At best, I've seen it takes around 6 to 7 months also to even start with the conciliation proceedings. अगर आपका बहुत ज्यादा लेट हो गया है, इनऑर्डिनेट डिले हो गया है और वो लोग कुछ कर ही नहीं रहे हैं, you can keep writing to the MSEFC saying कि you please move ahead with the process. ये प्रोसेस जो होता है वो टाइम लिमिट फिक्स्ड है एमएसएमईडी एक्ट के तहत. तो अगर आपको देखना है कि अगर आपके बहुत ज्यादा पैसे अटके हैं और एमएसएमई कोई एक्शन नहीं ले रही है, तो आप रिट में जा सकते हैं अपने हाई कोर्ट में, ये डायरेक्शन मांग के कि एमएसएमई को डायरेक्ट करे कि वो आपका जो प्रोसीजर है वो उसको जल्दी कंक्लूड करे. तो यही आपके पास एक प्रोसेस है जिससे आप एमएसएमई को डायरेक्ट करा सकते हैं कि वो आपका टाइम लिमिट में खत्म कर दे प्रोसेस प्रोसीजर. बट देन आपको उसके लिए भी थोड़ा खर्च लगेगा, आपको एक रिट फाइल करना पड़ेगा, एक एडवोकेट रखना पड़ेगा. तो आप हमेशा देख लीजिएगा कमर्शियल विजडम है कि आपका कितना पेमेंट बाकी है आगे वाले से, और लेट होने पे आपको कितना लॉसेस हो रहा है. तो दिस इज बेस्ड ऑन अ कमर्शियल डिसीजन. अगर आपके पास आपका छोटा पेमेंट है तो यू कैन जस्ट वेट, एंड द एमएसएमई गाइज वुड समडे would obviously take up your case, क्योंकि अब हम लोग कुछ कर नहीं सकते. गवर्नमेंट ऑर्गेनाइजेशन है, द गवर्नमेंट ऑफिसर्स डू देयर वर्क ऑन देयर ओन पेस. तो ये वैसे ही चलता है जैसे कभी कभी सिविल सूट चलता है, बट देन मोस्ट ऑफ द टाइम्स मैंने देखा है कि इसमें जल्दी रिजॉल्व हो जाते हैं डिस्प्यूट्स. नॉट टू
सर हेलो
हाँ यस
सर, इसमें प्रॉब्लम क्या है? एक्चुअली आई हैव अप्लाइड ऑन समाधान पोर्टल in the year of 2016, and
Okay.
after that they have not given any response to us, and after 3 years I have lodged a writ petition in High Court.
Okay.
And in High Court nowadays nobody will give any direction. Now case has already been dismissed, but they have court direction is that don't come, you go there and wait for that.
No, it cannot be. It couldn't have. मतलब कि ये डायरेक्शन बिल्कुल वैलिड नहीं है सर. ऑर्डर में देखिए, ऑर्डर में तो कोई भी कुछ भी पास कर सकता है एक बार के लिए.
एक्चुअली कैसा है सर, इसमें जो जज ने क्या किया है हमको कि ये नॉट बिफोर दस, उन्होंने उसमें मेरा इसमें पेमेंट है 29 लाख का है. और ये बंदा क्या किया कि हमने समाधान पोर्टल पे लॉन्च करने के बाद वो जो अथॉरिटी है वो तो हियरिंग ले रहा ही नहीं. वो क्या बोलता है कि आप रीट पिटीशन दाखिल करो. तो पोर्टल का क्या मतलब है? वंस वी हैव अप्लाइड ऑन ऑनलाइन,
बिल्कुल आप बिल्कुल सही बोल
गिविंग
रहे हैं
ऑल
सर.
डिटेल्स.
अगर ऐसा हो रहा है तो आप मुझको प्लीज वो रिट पिटीशन भेजिए, उसका ऑर्डर
हाँ।
भेजिए जो हाई कोर्ट ने ऑर्डर पास किया
Actually,
था।
no, sir, no. Just listen me, sir. High Court order, we have just withdrawn it from court.
ओके,
We
मुझको
have
तो नहीं
already
लगता सर कि
withdrawn,
आपके साथ
but
सही हुआ है, क्योंकि क्योंकि
sir, हाँ
मेरी बात
सर वही
सुनिए।
बोल रहा हूँ।
हाँ,
नहीं, मेरा एक सवाल ये है सर कि एक्चुअली हम जब ऑनलाइन पोर्टल में हम जब सबमिट करते हैं अपना कंप्लेन, तो जो अथॉरिटी है, जो डिस्ट्रिक्ट इंडस्ट्री सेंटर की, उन्होंने हमको कॉल करना चाहिए। वो क्या बोलते हैं, आप एक काम करो, पिटिशन फाइल करो। दे अगेन गिविंग some documents to us, just prescribed format, and just go over the details, and then we will keep one hearing in front of us. तो ये कैसा है फिर? What does it mean about keeping this
देखिए आपको
portal,
मैं
some other
बताता हूँ कि अलग अलग एमएससीएफसी का ना अलग अलग प्रोसीजर होते हैं टू फाइलिंग। जैसे कि जहां तक कि मैंने देखा है कि मैंने 5 6 7 एमएससीएफसी के साथ तो मैं काम करता हूँ, तो बहुत जगह होता है कि आपने अगर ऑनलाइन एप्लीकेशन डाल दिया तो फिर आपको कुछ देना नहीं होता है। वो लोग छोटा छोटा डॉक्यूमेंट्स मांगते रहते हैं मेल में, आप वो सब देते रहेंगे उनको, तो कोई दिक्कत नहीं होती है। लेकिन कुछ कुछ एमएससीएफसी का बिल्कुल रिडंडेंट प्रोसीजर है, जो कि मुझको भी
और
नहीं लगता है सही है लॉ में, कि आप ऑनलाइन एप्लीकेशन करते हैं एक बार, फिर वो ऑफलाइन एप्लीकेशन का आपको प्रोसीजर फॉर्मेट देते हैं, फिर आप वो भरते हैं और उसके बाद फिर से सबमिट करते हैं, तो ऑनलाइन तो एप्लीकेशन ही रिडंडेंट हो गया एक बार के लिए। तो
वही तो
ये
हो गया
सब,
ना सर, उसका
हाँ
मतलब ही
ये
नहीं रहा ना।
एग्जैक्टली ये इनका खुद के बदमाशी है सर। ये आप बोल सकते हैं
हाँ,
कि कोई कोई स्टेट में एमएससीएससी वाले ऐसा करते हैं, हिमाचल में मैंने
वो
देखा
तो
है होता हुआ, पंजाब में मैंने
हाँ,
देखा है सेम चीज होता हुआ। तो ये सब वहां के
हम्म,
लोगों का अननेसेसरी डिमांड्स है, जो कि अगर
हम्म,
आपका कोई एक अच्छा वकील हो और एक अच्छा जज होता, आपका सिंगल जज, आई डू नॉट नो कि व्हाट ही हर्ड एंड हाउ डिड
सिंगल
ही
जज
पास
है
एन ऑर्डर।
एक्चुअली। हमारे यहाँ पे औरंगाबाद जो है ना, इस कोर्ट में ये जो डिलेड पेमेंट सिस्टम का जो ये है ना, वो उसमें एंटरटेन नहीं कर रही है। ये काम
ये
हमारा है
बिल्कुल
क्या, ऐसा
ये
बोलते हैं।
बिल्कुल गलत है सर। आप अगर वो एंटरटेन नहीं कर रही है तो लेट देम डिसमिस। आप बोलिए कि आप मेरा डिसमिस करो रीजन देके, विल अपील इट। आप ऐसे सिंगल जज आपको रिकोर्स
हाँ,
देने
वो
से, रिलीफ
हाँ,
देने से मना नहीं कर सकता, समझ रहे हैं? अब हाईकोर्ट जज भी है
हम्म,
वो,
हम्म,
अगर वो गलत जजमेंट पास करेंगे तो ऑब्वियसली आप अपील करेंगे ना। तो अगर वो ना, मुझको तो सुन के ही बहुत अजीब लग रहा है कि आप रिट पिटीशन में गए, उन्होंने 4
सर,
साल से आपको
आप
कोई।
मुझे, मैं आपको सारा डिटेल दूंगा सर, मेरा पूरे डिटेल मैं आपको भेजूंगा। इसमें हम, आप हमको क्या, किस टाइप का हेल्प कर सकते हो बताओ। एक्चुअली
बिल्कुल
कुछ
बिल्कुल
समझ नहीं पा रहे इसमें कैसा है।
बिल्कुल, आप मुझको अपने पूरे डॉक्यूमेंट्स दीजिए, उसके बाद मैं आपके डॉक्यूमेंट्स देख के आपको बताता हूँ कि आप क्या कर सकते
ओके, किस नंबर पे भेजना है आपको सारा डिटेल?
हैं। मेघा वुड कनेक्ट यू विथ मी।
ओके सर, थैंक यू,
हाँ,
थैंक यू।
थैंक यू। सो एक सेकंड में और क्वेश्चंस देख लेता हूँ। There are 2 3 suppliers facing problem of delayed payment. Can we do claim together or claims should be individually? Claims should be individually. You cannot take all the parties into a single claim. आपका अलग अलग ट्रांजैक्शन है अगर सबके पार्टी के साथ, तो वो सब अलग अलग एप्लीकेशंस फाइल करने होंगे आपको। So that was the answer. How much maximum reminder we can send after 45 days and file suit for delayed payment? मैंने जनरली देखा है कि एमएसएमई की वेबसाइट जो है वो 6 7 महीने अगर आपका डिले हो गया 45 डेज, तब तक तो आपका एक्सेप्ट ही नहीं करते हैं रेफरेंस एप्लीकेशन। मैंने कभी कभी देखा है कि कर लेते हैं, कभी कभी नहीं करते। तो आप ऐसा एक रफ एस्टिमेट पकड़ सकते हो कि 45 डेज के बाद अगर आपका भी डिले हो रहा है तो आप उनको बताते रहिए कि आपका इंटरेस्ट एप्लीकेबल होगा, आपका इंटरेस्ट लग रहा है। और जैसे ही आपको एमएसएमई रेफरेंस का जो समाधान पोर्टल है आपको केस करने दे रहा है, आप एज सुन एज पॉसिबल आप केस कर दीजिए, समझ रहे हैं? तो देर इज नो टाइम लिमिट टू से कि आप इसके इतने दिन बाद अपना सूट कर सकते हैं, बट मेरे हिसाब से 6 7 महीने जब बीत जाए तभी करना चाहिए। If MSME creditor was defaulter of statutory obligation, still he is eligible for filing of case against their delayed पेमेंट। यस, आपका स्टैट्यूटरी ऑब्लिगेशन के आप डिफॉल्टर हैं तो उसका जो पेनल्टी है, उसके जो वो है वो एक अलग है, वो एक अलग चीज है। तो वो आपको उस हिसाब से पेनल्टी और जो भी चीजें होंगी नॉन कंप्लायंस के लिए स्टैट्यूटरी ऑब्लिगेशंस के, वो आपको फेस करनी पड़ेंगी, बट आपका रजिस्ट्रेशन नहीं कैंसिल हो जाएगा। आप समझ रहे हैं? वो आपको आप कुछ शायद इलीगल एक्टिविटी करेंगे या फिर एज सच कोई बहुत ही ज्यादा अग्रेवेटेड फॉर्म में कुछ ऐसा करेंगे इलीगल काम, जिससे कि आपका रजिस्ट्रेशन कैंसिल हो तभी हो सकता है, अदरवाइज आई डू नॉट थिंक कि दे वुड कैंसिल योर रजिस्ट्रेशन अंडर एमएसएमई। तो मैंने सारे Q&A तो आई गेस देख लिए हैं। इफ देयर इज एनी अदर क्वेश्चंस।
Yes, Jitendra ji, would you like to ask a question? Since we are running with the time, so you can quickly ask the question if you are there. Please unmute Jitendra ji, and if you are available, please ask your question, Mr. Jain.
Yes, ma'am.
Yes, please ask.
यस मैम, हमारा एक क्लाइंट है, हमने उसमें ERP सर्विस का दिया था। तो मैडम विद इन 2 साल या फिर 1.5 ईयर से पेमेंट नहीं आ रहा है उनका। तो हम रेगुलर फॉलोअप करते, मेल्स भी डाले, मेल्स थ्रू पर फॉलोअप चलता है कि हर रोज मेल फॉलोअप करते, लेकिन स्टिल पेमेंट नहीं आ रहा है। तो फिर हम MSME थ्रू जा सकते हैं?
हाँ, अगर आपका एमएसएमई में रजिस्टर्ड है आपका जो एंटरप्राइज है वो माइक्रो या स्मॉल में रजिस्टर्ड है ऑलरेडी, आप जब उस ट्रांजैक्शन में एंटर करे थे अपने ऑपोजिट पार्टी के साथ जिनके साथ आपका पेमेंट ड्यू है, उससे पहले
Okay.
अगर आप रजिस्टर्ड थे एमएसएमई में किसी भी कैटेगरी में एक्सेप्ट मीडियम, तो आप एमएससीएफसी जा सकते हैं।
ओके, पर सर उसके लिए मेरे पास कोई वर्क ऑर्डर ऐसा कुछ ऑर्डर नहीं है मेरे पास, सिर्फ इनवॉइस है।
तो आपको एक सर्टेन फॉर्मेट में एफिडेविट होता है, वो आप मेघा से कनेक्ट कर लीजिएगा, वो हम लोग आपको दे देंगे। तो आप वो एफिडेविट कराना पड़ेगा आपको कि हाँ मुझको ऐसे ऐसे कंडीशंस के साथ वर्क ऑर्डर मिला था, तब आप फिर वो एफिडेविट के साथ अपना केस फाइल कर सकते हैं।
ओके। और सर आपका अगर आगे मुझे कुछ हेल्प चाहिए तो फिर सर आपका फीस क्या होगा?
सर वो ना आप एक बार मेघा से जब मेरे साथ कनेक्ट करेंगे, मैं आपके डॉक्यूमेंट्स देखूंगा, तो फिर मैं आपको एडवाइस कर पाऊंगा कि मेरे चार्जेस कितने होंगे।
मैं मेघा से कैसे कनेक्ट करूं?
मेघा
अभी
अपना
आफ्टर द सेशन हमारी टीम में से आपको कोई ना कोई जरूर कांटेक्ट करेगा, ठीक है? और हमने अपना नंबर, एड्रेस और ईमेल आईडी सब छोड़ा है चैट सेक्शन में, अगर आप चाहे तो आप भी हमसे कांटेक्ट कर सकते हैं। So once we have a discussion, telephonic discussion or anything, we'll get you connected with Prateek ji directly. ठीक है? Then आप आराम से अच्छे से उनसे बात कर सकते हैं, howsoever, webinar पे या कॉल पे या पर्सनल मिलके, जैसे भी आप कंफर्टेबल होंगे, we'll get you connected.
आप सर आप कहाँ से बेस्ड है?
मैं बेस्ड आउट ऑफ पटना हूँ, लेकिन मैं दिल्ली और पटना दोनों जुरिस्डिक्शन की केसेस करता हूँ, तो इट इज नॉट फार फ्रॉम पटना। देयर इज ओवरनाइट जर्नी, तो आई टेक केसेस बोथ इन दिल्ली एंड पटना।
ओके सर, हम
दीज आर द टू
गुजरात
जुरिस्डिक्शन इन व्हिच आई प्रैक्टिस।
ओके सर, हम गुजरात से, तो हो सकता है सर आप हेल्प कर सकोगे?
हाँ बिल्कुल 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 कर सकेंगे। अगर आपको कोई सच वहां पे ऐसा कोई जरूरत आएगा जिसमें आपको एडवोकेट की जरूरत हो, और फिर ऐसा हो कि आपको उस एडवोकेट से मिलने की जरूरत पड़े, आपका फिजिकल प्रेजेंस जरूरी हो, तो हम लोग आपको ये भी बोल देंगे कि आप वहाँ किसी लोकल काउंसिल को हायर कर लीजिए। बट देन जहां तक की जरूरत नहीं पड़ रही है कोई फिजिकल मीटिंग की, वहां तक हम लोग आपको हेल्प कर सकते हैं। दैट इज नॉट अ प्रॉब्लम।
ओके ओके सर, ओके,
Thank you.
थैंक यू। लीगल नोटिस
Prateek ji, shall we end the session now?
No problem. It was wonderful to be a part of it.
Seriously, yeah. Thank you to all the participants. Basically, our goal today with Prateek ji was only, to empower all the MSMEs, new entrepreneurs and enterprises to combat all the common challenges or queries which arise due to, delayed payments. So we hope with our expert advice, Prateek ji with us, we were able to not only resolve but give you a right insight for what kind of a documentations, how documenting and recording your transactions is important, and what is the right time to appeal, or probably how if you already prepare an agreement, how these things can not only safeguard you and your businesses, but it open your eyes for other interactions and transactions you do in your businesses every day. So I think along with my entire team at UDYAMITA and with all the participants who were present here with today, I would like to extend my warm gratitude to our guest speaker, Prateek ji. As always, his patience and his invaluable insights shared today with us. I'm sure most of my participants have truly benefited. And so not only benefit through the insights and the knowledge and the kind of a presentation he gives, but I'm sure after this also, if you want to lend, you want to have his hand holded for your projects, he's available. So you can get in touch with us and we'll put you directly to Prateek ji. And I'm sure, there's a idiom saying, God help those who help themselves. So, we have to stand for ourselves. We have to stand ourselves and go in a right path. Like Prateek ji had already mentioned, see, if the law exists, we should know it. I really liked it when he said that. So it's like most of us don't know the right thing and right procedure to go about. This is what I've been noticing in this entire seminar also today. So, he's there, he's letting you, he's guiding you throughout. So if we go on the right path, I'm sure our goal is very nearby. So we won't get lost. When somebody is holding our hand, so we don't get lost. This is the case here. And I'm sure with the right education today, what we have got, it will be useful to us in most of our transactions and businesses we are holding. So thank you, Prateek ji. Thank you.
So much. Thank you.
Each participant, thank you. And I will like to say goodbye today till we join again. So once again, anybody who's interested, put interested and we'll have our team get you connected. Thank you, Prateek ji. Thank you so much.
Thank you so much.
Thank you so much. Really grateful. Thank you.
Thank you.